Start now. Good morning, everyone. We'll just give some minutes to allow others to join. So we'll start in about 2 minutes time. Thank you.
Yeah, I spoke with him. Everyone says that he would get back to us in about 2 to 3 minutes. He just landed in your last stage right now.
Sorry, if you're just joining, just to let you know that we've given about 2 minutes to allow others to join, and we'll start in about 1 minute. Thank you. Right, so I think it's a good time to start. We have a good number now. Good morning, everyone. I hope you can all hear me. Um, I am the convener and the lead facilitator for this training session. My name is Abayomi Okubote, and you get to see, my faces for the next 2 days. It is my pleasure to welcome you all to this important training. This is a rare opportunity for SMEs in Nigeria, Ghana, and Mozambique to acquire the necessary knowledge for resolving their disputes outside the courtroom, and to also understand the principles of contracting. The training is essential due to what we call the prohibitive cost of resolving disputes through litigation. And this prohibitive cost has made litigation court actions to become unattractive and unaffordable for SMEs. By necessity, it is important that SMEs are able to resolve their dispute in a manner that is cost effective, efficient, and one that enhances business sustainability. As you see from this slide, SMEs are very important. In fact, the SME sector is the backbone of major economies, as well as they are important contributors to employment, economic and export growth. In Nigeria, as you see from the slide, SMEs contribute 48% of the national GDP and account for 96% of businesses and 84% of employment. In Ghana, SMEs contribute an estimated 70% of Ghana's GDP and account for about 85% of employment in the Ghanaian manufacturing sector. And if we move away to the southern part, South Africa SMEs account for 91% of businesses, which is quite high, and 60% of employment and contribute 52% of the total GDP. Now, despite the significant contribution of SMEs to different economies, challenges still persist, which hinder the growth and the development of the sector. There was an independent survey that was conducted by a UK agency on the small and on SMEs in the UK to discover the financial impact of legal issues on SMEs. And the result of that survey is that SMEs SMEs are losing more than 13.6 billion yearly on legal issues. The survey has provided some shocking revelations that should make every business sit up and take notice, because it is almost impossible to imagine what impact the loss of 13.6 billion will have on the SME economy. Another analysis by Escalate Survey 2019, which I've also put on the screen, shows that 96% of SMEs regularly experience commercial disputes. So as an SME business owner in any industry or sector, engaging properly with your legal issues and guarding against them, is going to potentially save you millions of naira every year. Simple matters like having contract terms and conditions checked or drafted properly to ensure your employment or contractual terms are clear will de-risk your business rapidly. And we have a session covering contracting, which we'll take shortly. It is also important to manage your disputes efficiently or establish safety nets to sidestep them. I've advised several SMEs, and some of their complaints are, as you see those complaints on the screen, legal action is difficult to justify because it takes longer to receive a payment overall, or they even say they paid in the end, legal actions pay in the end by their rules and not mine. It can be too time consuming and cost prohibitive. It is too expensive to instruct lawyers. Some even conclude that the process is not worth it and only puts financial pressure on the business. So whilst this complaint may be true for traditional litigation or courtroom actions as we know them, ADR provides useful alternatives that will not only help to obviate the concerns, but also help the business to continue to run as a going concern. So this training is designed to help SMEs understand the rudiment of contracting, nuances of contract management, dispute avoidance and prevention, the various ADR methods, the pros and cons of ADR, how SMEs can explore this knowledge for their business growth and sustainability. And to handle this, we have lined up some of the finest practitioners in the world of ADR to teach at this training. And we hope you find the sessions rewarding. In the event that you have any concerns or any questions, you can always reach me as a lead facilitator on the email addresses, and also some of the associates working with us. Now, for the first session for today, starting with understanding the principles of contracting, we have Mrs. Laura Alakija, who is the managing partner at Primera Africa Legal, a top-tier commercial law firm in Lagos. Her expertise spans the disparate yet connected fields of disputes and transaction advisory services. She has over 15 years experience in project finance, power and infrastructure, asset acquisition, energy and natural resources, and dispute resolution. Laura is a fellow of the Chartered Institute of Arbitrators, an accredited mediator, and a certified ODR expert. She has served as counsel and arbitrator in several disputes and led the team representing clients in a number of big ticket transactions in Nigeria. Our profile is a long one, but maybe I will just cut it short at this point. It is my pleasure to welcome Mrs. Laura Alakija to take our session. Thank you.
Thank you, Abayomi. Good morning, and good morning to everyone on the platform. I thoroughly enjoyed that introduction and a bit of background on SMEs in Nigeria. I thought the statistics were quite interesting to see the sort of role the SMEs play in our economy and the level of employment they provide to the Nigerian. I didn't know, or I didn't have those figures, and I didn't realize that the workforce was larger among privately owned businesses, especially the small and medium scale businesses, as opposed to the large corporates. So that's really a good point for me to take off. The conversation is going to be brief, as relaxed and informal as possible, and I've deliberately avoided all forms of legalese so that we can have an open and an easy conversation. I would appreciate it if the session is as interactive as possible, so please feel free to drop your questions in the Q&A section while the conversation is going on, so that we can have a little bit of back and forth during the course of the presentation. Like Abayomi mentioned, I'll be speaking to you primarily about contracting, and the speaker who's coming in after me will give you a bit more information So I will keep these to the basic, what your legal obligations are, and so that you can sort of prepare yourself early on to avoid and or manage your disputes without much hassle.
Laura, sorry, is it possible
Laura,
can you hear me? Is it possible that you possibly take off your camera so that you save bandwidth, because we kept
to help with the connection? Yeah. Okay, I'll do that right away, and I will also be sharing my screen so that everyone can see my presentation. Just a moment. Okay, got that. Can you see my screen?
Yes,
yeah? Okay, perfect. All right, so I will not go into much of an introduction because Abayomi has said everything, but I've provided a small outline into what the conversation is going to look like. And I will talk basically, about what to expect in terms of contracting, and then the different parts of a contract, what to do to avoid and prevent disputes as much as possible. So to save some of that revenue that Abayomi mentioned earlier, that SMEs lose to disputes and dispute resolution. And then I'll talk a little bit about negotiation and regulatory compliance issues. So just everything you need to know to put your business in good standing so that you don't have a lot of issues. So I'm digging right in. So I'm starting with contracts. And I think that the general understanding of what a contract is when people hear contracts, they think it's a legally binding document. So obviously it's in writing and people have to sign it before they have a binding agreement. To a large extent, that is true, but a contract sometimes could be oral. It could be written, so two parties may not sit down and sign it, and you can still find that it's a valid contract. And we'll talk about that in due course. But the key thing to notice about a contract is that it is usually between two or more people, and there's usually the intention to create binding legal obligations. A contract usually constitutes offer, acceptance, consideration. That means money should exchange hands. The intention to create a binding legal obligations. Capacity means that the parties going into contracts cannot be minors or mentally incapable of going into a contract. So they cannot be people of unsound minds. And the two parties should be aware that they're going into some kind of contractual relationship. So basically, those are the elements that form a contract. Now, I mentioned that sometimes a contract is oral, and I'll give you an example. If you, well, this is really before Uber, but let me work with this example. If you hailed a taxi, you know, and the taxi man stopped, and you said, "Oh, I'm going to," let me say, Ahmadu Bello Way. I think almost every state has an Ahmadu Bello Way. And you say, "I'm going to Ahmadu Bello Way," and the taxi says, "Okay, I'll take you there for 500 naira." And you say, "Okay," and you get into the taxi. You just entered into a binding legal contract with the taxi driver. The contract is for transportation of yourself and maybe some goods or whatever you're carrying from point A to point B. So you can see that there was an offer. The taxi driver made you an offer for 500 naira. There was acceptance. You accepted to pay 500 naira, I'm sorry. There's consideration that 500 naira is going to change hands between you. It's a legally binding contract. When you give him, or once you get into that taxi, he has a legal obligation to take you from point A to Ahmadu Bello Way. And you have a legal obligation to pay him 500 naira for taking you on that journey. Capacity may or may not apply here, because I think if you're under 18, you can still take a taxi. But under the circumstances of this conversation, or the context of this conversation, is that you must be of legal age to be able to enter into a contract, and you cannot be of unsound mind. So if you have someone with mental issues and the inability to understand what they are going into or what a contract is, cannot execute a contract. And of course, the two parties must be willing to be bound by the terms of the contract. So the taxi driver and yourself must be willing to, must know that you are getting into this relationship, and this is the purpose, and this is, you know, these are the terms, so this is the consideration that's passing. So in summary, that's what an oral contract looks like. The difference between that and a written contract is that you then sit down and you put all those into writing, and you put a number of other terms that govern the relationship. But I will not go so much into those details at this point in time. And I think that you will get this presentation deck after the meeting. So I will not go over everything that is written in each slide, but you will find that you can refer to this material. So in terms of running a small business, you will find that contracts are something that you deal with on a regular basis, whether they're written or oral, whether you deliberately put them into writing or not. Once you enter into an understanding with somebody that you supply XYZ service, obviously you've gone into a contract. So for instance, if your business is selling some kinds of goods or services online, you will find that once somebody goes to your page and places an order, you have a contract to deliver XYZ products to them. And you will see that all the 6 elements will run through your transaction. So there'll be offer, there'll be acceptance, there'll be consideration, there will be the intention to create binding legal relations, there will be questions of capacity, and obviously the transaction will run both ways, so it will be mutual. So on a daily basis, you will find that you deal with contracts whether or not you're conscious of them. And it's important to bear that in mind, because what tends to happen then is, even for the unwritten contracts, you have certain legal obligations to your customers or clients to be met. This is why oftentimes disputes arise in business, because whether those obligations are spelled out in black and white or they are implied. Again, I'll go back to the example of the taxi driver. Even though your contract is not in writing, what is implied from that relationship is that the taxi driver, for instance, can drive, has the authority to drive that taxi, has a valid driving license, and he will take you from point A to point B without any interference or any unnecessary drama. So for instance, if you get into that taxi and the man says, oh, I'm really sorry, I need to take my mother to the market. I need to stop here and pick up my mother. And then after that, oh, I'm taking my son to school. I need to stop there and pick up my son before we get to Amadu Bello Way. Your first reaction will be like, excuse me, Oga, I'm paying for this ride. Please take me to my destination before you take all those details. So obviously, it is implied that when he has entered into this contract with you, if it is a car hire service, the expectation is that it is an exclusive contract. That means you will be the only passenger in that taxi until you get to your destination. So there's an implied term of exclusivity. Obviously, on your part, the taxi driver will have an expectation that you will pay your fare, you will not damage anything in his car, and you will not take any details. Excuse me. So there'll be some expectation that you will not say, oh, Oga, please wait, I need to polish my shoes, then I need to pick up my dry cleaning. It's a meeting I'm going for at Amadu Bello. You see, the taxi driver will also now raise his own objections. Madam, we've agreed 500 from point A to point B. You cannot add all this extra, because by adding those extras, it means you are changing the terms of your contract. So what was implied as, oh, these are the terms of this transaction, suddenly they are changing. And then you see that there's resistance, or there's an attempt to bill you a little bit more. So disputes generally arise from those kinds of circumstances where there are legal obligations and parties feel maybe those obligations are not being met, or there's some misunderstanding as to how they should be met. So this is why contracting is very important. It's important to know what service you're rendering, how and when you're delivering it, at what price, and to fix those in such a way that you manage the expectations of your customers or your clients, such that you don't run into issues in future. So very quickly, I'm going to run through the kinds of contracts that you're likely to encounter on a day-to-day basis. You have letters of intent, memoranda, I think that's the plural of memorandum, memoranda of understanding, confidentiality and non-disclosure agreements, sale and purchase agreements, service level agreements, or employment letters. I mean, these are just examples. Depending on your business, there's a wide variety of contracts that you could be going into. And you need those contracts to be able to spell out what service you're rendering, why and how, and at what price. So the next thing is, well, when putting together a contract, usually the drafting requires a step-by-step inclusion of the specific terms and conditions that cater to the needs of the parties under that contract. I'm not trying to teach you how to draft a contract, obviously, because under Nigerian law, as of today, it is still illegal for non-lawyers to draft contracts or other legal documents. And I think the exceptions are very narrow. Maybe to people that work for lawyers, you can draft contracts for your principal. So say you're a legal secretary or you play another function in a law firm, you can draft a contract for your principal. But generally, it's prohibited under Nigerian law. And I think it's punishable by a fine or imprisonment. So I'm careful not to tell you that please go and draft your own contract. But the idea is to point you in the direction of what to do and what to look out for. In my experience working with businesses and doing their contracting, I found that the clients I have who seem to have good relationships arising out of their contracts, or who have the best, let me not say good, because you can still have a good relationship with your business partner if you just call your lawyer and say, okay, take this, draft this and send it back to me. If you have a good lawyer, you should have no issue. But as a business person, this awareness is useful to you because it helps you to understand what product the lawyer is delivering to you and whether it satisfies your business needs. So that's one of the reasons for this conversation. In order to understand every contract document that comes before you, you need to bear in mind that your contract will be split into 3 key parts: the introductory part, also known as the recital, the commercial and operative parts. Usually they're just called operative parts, but I like to spell out commercial specifically so that for business people, those are the clauses that you are really interested in. It's good to be interested in all the clauses of your contract, but obviously you will lean more on your lawyer for all the other clauses. For the commercial parts of the contract, you'll give them the information, but they'll need to draft it in a way that covers everything that you desire. So it helps to have an idea what's going on in your contract, and the bulk of what really happens in your contract is in the commercial and operative parts. And then you have the concluding part of the contract where the parties sign and all of that. So the introductory parts, which is also known as the recitals, usually would contain the names of the parties, their addresses. If it's a company, it will indicate that, this is your registered address or your principal place of business. For some contracts, they might even want to add your registration number just to show that you are a valid legal entity. So it will have that, and then it will have the purpose of the contract. So if you look at a contract, you might see something like whereas, then you will now see a description. Company XYZ is a seller of aluminium sheets. It's desirous of going into a relationship with company ABC for the distribution of their aluminium sheets in the eastern part of Nigeria. The parties have entered into this agreement to define the terms that govern their relationship. So some background information, then you now go into the operative part, and usually that operative part would start with language like, it is now hereby agreed as follows, or if it's a little bit more legalese, you see in witness whereof the parties now agree as follows. Then you will see your commercial terms. And so your commercial terms would usually then start with a description of the service. It will say the price. If the payment is, and it will say payment terms, so it could be a one-off upfront payment. It could be instrumental payments. It could be by wire transfer. It could be a check. It could be a cash payment. The commercial part spells out the details of the business. So you see that part, in my experience, is the part that most businesses pay attention to, because they want to see that you have everything that they require in terms of getting the commercials right. So that part will usually come immediately after the introductory part and the recitals. And then the operative parts, it now contains other clauses like it may spell out the obligations of the parties. So things like, for instance, it could say the seller would be responsible for packaging the products, transporting them this way, delivering them within XYZ days. So those kinds of terms. And then it could state the obligations of the buyer, or the buyer has obligation to make payments at so time. They have the obligation to pick it from Port C, title and custody of the goods pass at this point. So it depends on what the parties agree. The seller may be responsible for the goods from the time they leave your shop till they arrive, meaning that if they get lost in transit, you have the duty to repay. Or the buyer may be responsible for the goods. That means custody and title would have passed to the buyer at the doorstep of your workshop. So once it leaves, if something happens in transit, then the buyer is responsible. Now, the nature of goods, the business the relationship, and what the logistics are for getting your services or your goods from point A to point B will determine what the risk and custody, what the custody and transfer of title terms would be. But those are examples of the kinds of things that you have in the operative parts of your contract. And I'll discuss those in detail. We also have what you call boilerplates. I'll discuss them further down in the conversation. And then eventually you have your concluding parts, which has to do with signatures. So all of these are broken down. I will not dwell too long on them, but I'll share enough information to at least give you an idea what you're looking for. So I'll start with the commencement. In the early parts of your commercial and operative parts, once you've passed the introduction, you will see something like the commencement. Sometimes the date actually comes before the recitals. It depends on how the contract is structured. So you will see that, oh, this agreement is made on the 5th day of April 2001. That's the date of the contract. Now, unless it states otherwise in the body of the document, there's every likelihood that that's the effective date. By effective date, I mean that once parties have signed it, that date on top is when the contractual relationship has kicked in. But sometimes you will have different dates in the same contract. So you will see that some of the examples I have there, you have the execution date, that's the date you sign, different from the effective date, that's when your obligations kick in. So you may sign the contract on the 1st of April, but decide somewhere in the body of the agreement that the contract becomes effective on the 15th of April. Maybe that's when you really need for your legal obligations to kick in. And when that agreement becomes effective on the 15th of April, you may decide that the commencement date for the services that you are going to render should start on the 30th of April. So this is, let me give you a practical example. This is what I mean. So in a contract like that, let's assume it is a contract for, let's say, supply of, let's say diesel, for instance. Let's say it's a contract for supply of diesel, and the effective date is first, the signature or the execution date is 1st of April. That means you've looked at all the terms, you get together, you sign it on the 1st of April. Nothing happens from the 1st of April because that's just the execution date. Note that these dates only apply in that way if they are indicated in the contract. Then your effective date may be 15th of April. So by 15th of April, your obligations can now kick in. And the buyer may now send you a request for 2,000 liters of diesel. When you receive it, you are now supposed to supply. But maybe you've decided that, commencement date should be on the 30th of April. So even if the seller, if the buyer sends you a request for diesel, for 2,000 liters of diesel, but you get that request on the 16th of April, for whatever reason, maybe 30th of April is the time that you would have had your diesel trucks and everything in place, so you can't start supplying till then. So people can pre-order, but you know that the commencement date for your deliveries is on the 30th of April. So that's what you've entered in your contract. So if somebody sends you an order for your 2,000 liters of diesel and you get the order on the 16th of April, you don't have a contractual obligation to deliver before 30th, because by your contract, you've agreed that commencement date for supply is on the 30th of April. So before 30th of April, all you can get is pre-orders. and then by 30th, your obligation to actually deliver the diesel to their physical location will now kick in. So, those are little nuances that, because it's your business and it's your industry, sometimes, and maybe you're still setting up, or you're running some things that will make it difficult for you to start delivery at a particular time. It's good to know those things and specify them to your lawyer so that they don't give you a document that gives you binding legal obligations before you are able to fulfill them. That's the point of understanding these dates. Okay, so someone asked a question in the Q&A session. I'm taking a break to answer it so that we'll have a small diversion before we go to the next part of the presentation. And this is from Deborah. Deborah says, if as a business owner you have a contract signed by both parties and there's a disagreement, will the contract be binding since it was drafted by a lawyer, but the owner of the business signed? Okay, I think they meant to say, but the contract was signed by both parties. So yes, it will be binding. Remember, what the law does not allow you to do as a non-lawyer is to draft contracts. But in terms of execution, you are the one that is entering into a business relationship and promising to do certain things. The only way the other party will be willing to agree that, okay, you can do this for them, is if you actually sign the agreement to confirm that, okay, I've agreed to do this. So it's actually legal. For written contracts, that's actually that's the way it works. That's for written contracts that require execution by both parties. Well, actually, I'll go into the nuances later, but that's the way it works. So you actually are supposed to sign it. You may not prepare the document, but from everything I've said, not only should you know the content, you should review it, and you should have a rigorous conversation with your lawyer before you sign it, but you are required to sign it. So please go ahead and sign once you have received the information. I see another batch of questions. I'll come back to those questions a little later in the presentation, because we'll discuss some of the issues that I can already see, and then I'll come back to that question. So I hope, Deborah, that I've answered your question. If I haven't, you can just indicate. So after you've agreed all your dates and everything, you put those in your contract and you move on from there. So that's an example of what your commencement should look like. Okay, so, in the commercial parts of your contract, like I indicated earlier, you will indicate details of the goods and services, price, payment terms, the nature and scope of relationship. I say that because the nature of some businesses may suggest. So, for example, the example I gave with the XYZ aluminum producing company that's looking for an agent to that's looking for, I shouldn't use that word, that's looking for someone to distribute their aluminum products in the eastern part of Nigeria. For that example, for instance, in that relationship, if the intention of the the aluminum manufacturer is that they just want someone who will buy in bulk from them at a discounted rate and resell. In that contract, you may see that the lawyer would indicate things like, oh, this contract is not intended to create a partnership, an agency, or an agency relationship. It's merely a contract for the supply of aluminum products from XYZ to XYZ. The reason that is said is often because sometimes you want to manage your legal liability. So, for example, you don't want a situation whereby someone who buys your steel products from the supplier now assumes that that supplier is your agent. That means they work for you, so you are responsible for their actions. So if they have any issues, instead of them dealing directly with that person, that distributor, they will now come and try to be suing you for the actions of that distributor. You want to state expressly in your contract, for instance, that this is a purely commercial relationship for supply of XYZ to this person who can then on-sell to the general public. So for that kind of, for that example of the nature and scope of the relationship, it helps to the parties to decide very early on in the transaction where responsibility and liability is. Once I've supplied my products to you and you've looked at them and you have certified them okay, you can't come back to me. Unless there's a fundamental defect, maybe like a factory defect. You can't come back to me if you mismanage them or they get stolen. If you promise somebody that you will deliver within 10 days and you have issues delivering, that's not my problem. So your customers cannot come back to me, they stop with you. We will agree what the terms of our relationship are. It's different from an agency. If I hire you as an agent, under the law, the principal and agent relationship is such that the principal will be liable for the actions of the agent. So it's different if it's an agency. And those are things that, you know, parties need to be careful and conscious about. If what you want to do is just supply, let the person on-sell, that's what you do. And you spell out in your agreement that this agreement is not supposed to create a partnership or an agency. So I am XYZ Aluminium Manufacturing Company. ABC Aluminium Seller and Distributor is not my employee, is not my agent, is not my partner. I simply supply in bulk to them. It may also be, for instance, that XYZ now wants to be the only person supplying your aluminium products in the East. Then you may now include the nature of your relationship will be in that scope and nature of your relationship, you may see things like exclusivity. So that person will be, that supply contract will be exclusive. That means you cannot enter into another supply contract with another person who is distributing aluminium in Eastern Nigeria. So that person, you may have seen it sometimes. You will see some companies will say, we are the sole distributors of LG in Nigeria, or we are the sole distributors of Samsung in Nigeria. It means they have an exclusive relationship. So everybody who wants Samsung products in Nigeria has to go through them. As a matter of fact, if you are in Nigeria and you want to buy 200 Samsung televisions, if you send your order to the Samsung head office in, is it Japan or Korea? Where is Samsung from? If you send your order to the Samsung head office, because of the exclusivity of their relationship with their sole distributor in Nigeria, please, that's an example. I don't know if Samsung has an exclusive distributor. But the point is, if you send your order to the head office in whatever country, there's every likelihood that they will refer you back to Nigeria and say, oh, go to this person, they will fill your order, because they have an exclusive relationship and it is spelled out in their contract. It will be a breach of the contract terms if they sell to you directly when they have a sole distributor in Nigeria. So those are the kinds of things that describe your relationship. And it is important to know these nuances, to understand them, and to look out for them so that you can guide your advisors. You can tell your advisors what you want. And I cannot emphasize this enough. Oftentimes, what I've seen happen in my time working as a transactions lawyer is that parties sit down, they negotiate, they agree what they want to go into. Then they now say, we need to sign something. Then they quickly call a lawyer. They give you a briefing. Oh, this is what we're going into. Please draft a contract. And then you go and you draft it and you come back, you give it to them. They just look over it. Okay, it looks okay. They sign and they go. They have not given you the benefit of the details and the nuances of their relationship. And if you didn't ask, or if your questions didn't go that far, you might miss out some things. So sometimes you will find that from a lawyer's perspective, lawyers prefer to at least be present during even your business negotiations. They may not say anything, or if the lawyer understands your industry and is a transactions lawyer, they may actually negotiate on your behalf and do strategy on your behalf. It depends on the scope of the engagement. But the point is, your advisors need to understand what you are getting into so that they can advise you properly. So advisors like your lawyers, like your insurance brokers, like your commercial advisors, they need to understand what you are going to so that they can give you proper advice. All these are useful to avoid serious conflicts that will cost you good money in the future. Okay, so I'm taking a pause to answer a question from Gregory Okusi, and he says, what part of the contract will negotiations take place? And then if goods are missing in transit, who bears the loss? Okay, so I presume that by your first question, what you mean is at what point do you negotiate? It depends on the nature of the transaction and how the conversations go. Negotiations will happen once parties have established that, oh, I have something you want and you're willing to pay for it. Once you get a sense that that exists between the two of you, you may immediately go into negotiations. And negotiations start from the moment the person says, oh, can you supply me 20 crates of 20 crates of what now? 20 crates of electrical fittings. Can you supply me, or 20 cartons of electrical fittings? And you say yes. The next thing that's going to happen is negotiation. How much? Then you will now say, oh, this is my price. And the person will say, okay, maybe the price is good for me or it's not. They may make a counter offer. You may accept it. Then things like, okay, if I pay today, how soon can you deliver? You know, what are the payment terms? Can I pay? Pay in 3 installments? Can I pay? Sorry, I was lost for a moment. I will share my screen again and continue with the question I was answering. So I was saying, the second part of the question is if goods are lost. Hello?
Laura, can I quickly butt in? I was thinking that since you are still on slide 6, and you have 21 slides, possibly if you can take the questions after the presentation, so you can go to your slides, then answer all the questions later. Thank you.
Okay, that's fine. I'll conclude this answer and move on, even though I won't go over the 21, but it's fine. So I'll just conclude this answer and then I'll go back to the slides. Thanks, Abayo. Right, so the second part of the question was if goods are missing in transit, who bears the loss? Again, it depends on the terms of the contract. It depends on what structures you put in place for custody of the goods while in transit. And I'll give you an example. It may well be that your contract for the supply of 20 crates of 20 cartons of electrical fittings, that you agree to deliver. If you agree to deliver, it means that it's more likely than not that what you agree in your contract is that title and custody will not pass until the electrical appliances have arrived at the buyer's location. Sometimes, depending on the nature of the relationship, there may be a third party in between. So you may have a transporter that you use, And sometimes parties enter their agreements in such a way that title and risk pass to the transporter. So the transporter will be responsible if anything happens. And then the owner now takes title and risk when the buyer, sorry, takes title and risk when the goods arrive at their destination. That's a possibility. So it's possible that title and risk will pass from the gate of the supplier or to the buyer. So if that's the case, then the buyer will be responsible from the moment, once the moment the crates leave the seller's gate, it is now your responsibility. If anything happens, that's not the seller's problem. Those could be because that's what you've agreed. It may be that you've agreed to come and pick up the goods. So once they've handed it over to you, there's no reason why they should bear responsibility. So whatever the circumstances are, parties will agree where title and risk pass. Sometimes title and risk may stop at the gate of the seller, but it will pass to a third party. That's your transporter. So depending on the agreement between parties, the title and risk may pass to the transporter. So if anything happens, it's the transporter that will be held responsible. Then when they get to you, you now take custody. So the other answer to that question is that sometimes it is possible that title and risk only pass when they are delivered to you, meaning that it is now the seller who will be responsible if something happens, or if it has passed to a transporter, then it's the transporter that will be responsible if something happens. But it's good to get these things clear at the outset so that one does not run into issues. So I'll go back to my presentation, and then like Abayomi recommended, we'll come back to the question and answer later. So in answer to that question, you see that we've mentioned a little bit about risk. So the next part of your operative parts of the contract will look at things like risk and how you allocate them. The one thing I'm going to start by saying about risk is, in order to effectively mitigate risk, parties need to allocate risk to the person that is best able or best suited to bear it. I'll repeat myself. When you are looking at the risks in a transaction, risk allocation needs to be done or needs to be assigned. As you allocate for each risk, you allocate it to the person best suited to bear it. Now, best suited does not mean that the bigger or the richer party is the one that bears the risk. But if they have the capacity to, and they are willing to for whatever reason, that's fine. So in terms of risk allocation, what parties do is sometimes in your contract, you will see things like representations and warranties. So representations will be like the things you say, like, I am the owner of this product. I have the authority to sell it. The product is of XYZ specification. It will provide X, it will perform XYZ functions, and things like that. So representations, you say things that establish your authority and your ability to enter into the transaction. Warranties would essentially spell out what happens in certain circumstances. So the popular warranties that everyone will be familiar with are the ones you see on goods. If you buy a product, you will see that it has a 1-year warranty, it has a 2-year warranty or 5-year warranty. That warranty simply means that for this period while you are using my product, I'm assuring you that it will perform XYZ service. In the event that it doesn't, then I will do XYZ. And warranties are very important. You need to only provide warranties as to the things that you can actually do. And you need to be careful that your warranty does not cost you far more than the value of whatever product you're selling. So it's good to look at your warranties, which is why sometimes you see for some products, warranties are given for certain parts of the product, not the entire product. Some people have return policies for a duration. For huge projects, you have what you call a commissioning period. You can call me back anytime. If one part of what I've built or constructed for you is not working, you can call me back. And so all of that is provided in your warranties. Now, if anything goes wrong, what do you do? That's where risk usually comes in. Who pays for what if anything goes wrong? And it's important to find ways to manage those risks. And sometimes it may even be that none of the parties to the contract can bear the risk. That's where insurance comes in. some risks are such that you can't bear it, I can't bear it, we insure it. So if anything goes wrong, it is the insurance company that takes this risk. You pay a premium for it, and they cover that risk so that if anything goes on, they are the ones that pay. So in your contract, you will see things like indemnities. After you've given your warranties, and you said if anything goes wrong, I can do, or these are the things I can do for you within this period, you will now have to indemnify the person you've given that warranty to. So what an indemnity means is that if, for instance, the thing that we are saying should not go wrong, if it actually goes wrong, I will bear financial responsibility for it. So if you even spend money, let's say I sell you a car and I give you a warranty that this car, you know, will perform X, Y, Z, you can come back, and then you are traveling from Lagos to Port Harcourt by road. And as you are going, out of nowhere, the brakes suddenly fail and you run into a tree. Thankfully, nobody is hurt, but the car is damaged significantly. And you spend another 1.2 million naira to fix it. An indemnity means that because I've taken responsibility for this, and this brake failure, you know, that which falls under all the warranties I've given you, this brake failure, I will now indemnify you. So if the accident had happened in a location where you could tow the car back to me, I would fix it. But if you had to fix it, then I will refund you. So I will indemnify you and hold you harmless against liabilities, damages, losses, and expenses incurred as a consequence of, okay, this one is third-party claims. I'm reading my example. So it depends on what the indemnity is. Those indemnities help to give your clients comfort that you can do what you say you can do, and you are ready to put your money where your mouth is. Now, the challenge with indemnities is that sometimes if you don't couch or cap your indemnities properly, they can wipe you out. I'll give you an example. A couple of years back, there was a pipeline. There was a pipeline leak in, was it in the Pacific Ocean now? I'm talking about the BP case. So British Petroleum was exploring crude in the sea, in the ocean, and there was a pipeline break, and the crude seeped into the water and affected surrounding communities, and they were working through a subcontractor. And the damage and the claims and the fallout of that oil spill was so huge. British Petroleum paid in billions of dollars, literally, to clean up the spill, to compensate people that had been affected by the oil spill. And all of that. Now they're working through a subcontract, the contracting between those two parties. Imagine if the subcontractor had just generally said, I will indemnify British Petroleum for any oil spill in the ocean. You know that subcontractor, because they don't have the capacity to pay for that kind of damage, their business will be wiped out because their indemnity was so wide and it was not capped, and the risk was placed with a party that could not bear it. That is just an example, but BP had to pay everything, and that contractor was still in business because I've not seen the terms of their contract, but I imagine that it played out that way because they had allocated risks in a particular way. Maybe BP had some insurance they had to fall back to in order to cover that. But that's an example for you to understand. So those clauses, they fall in the parts of the contracts that parties generally don't pay attention to. They're called boilerplates or midnight clauses. You just leave it for your lawyers. But sometimes it helps for your lawyers to understand the intricacies of your business so that even when it comes to these kinds of clauses, they can adequately protect you. I've talked about pretty much everything in here. Okay, how can liability be limited? I've mentioned. So what you can do to limit your liability is sometimes you cap your your liability. If you indemnify somebody, you can say the limit of my liability in respect of anything that goes wrong in this transaction is XYZ amount. Usually it's a reasonable amount, 100,000. If the other party, but if it does go wrong, I will cover you, or I will cover all your losses to the tune of, and then you cap your liability. That's one way to limit your liability. You can always use insurance, like I mentioned. Can I hold someone jointly or severally liable? Those are legal terms. I don't really want to go, and both of you are, say, for instance, supplying third party. What you want to look out for is that you are only liable for the things that, so that's what is called several liability. Several liability means that I'm responsible for my part, company B is responsible for their part. If the parties are severally liable, it means it's only my part of the contract that I'm liable for. But if you are jointly liable, it means if anything goes wrong on either side of the transaction, if you've agreed that you'll be jointly liable, then the third party or the counterparty can come against any one of you or both of you for something that goes wrong, even if it's not your side of the transaction. So those are little things that you should pay attention to. Are any types of damages excluded? In Nigeria, punitive damages, you can't just claim damages because you want to punish somebody. In a contract, what we have are what are known as liquidated damages. I don't want to speak too much legal, but it's a reasonable pre-estimate of what you anticipate you will lose if something goes wrong. This is useful for, especially for the seller side of the transaction. If I give you a contract to supply me 2,000 liters of diesel, I gave you the contract on the 16th of April, and you were supposed to, our contract was supposed to commence on the 30th. So you have made all arrangements to supply by 30th. Then at 11:45 p.m. of the 29th, I now quickly send you a message to say, oh, sorry, I don't need that diesel anymore. I hereby cancel my contract. If there's nothing in the contract that says, first of all, you can't cancel within XYZ hours of delivery, that's a problem. Or if you do cancel, then this is the implication. So liquidated damages will just look at the scenario and say, if you cancel the night before delivery, I've already bought this diesel. You will be liable to still pay XYZ for terminating this arrangement without a reason at such a minute after I've expended XYZ. So liquidated damages will look at the value of what you would have expended in preparation for that delivery, and then you put your liquidated damages at that value. It has to be reasonable. It has to show this is what you will lose before you can put it in a contract. When you do so, then it's easier when you go to ADR or you go to the courts to recover that amount of money. So that's just an example of the safeguards you can put in your contract. Okay, we'll talk about force majeure when we go to the Q&A, so I'm going to skip that. The essential part is to know that you can negotiate all aspects of your contract. Termination, these all fall under, so in your operative part, apart from the commercial aspects, there's what you call boilerplates. I call them boilerplates, or they're called boilerplates because those are like the legal clauses. So all those indemnities, warranties, and all those things, a lot of it is legalese, and commercial transactions, people tend to leave that for the lawyers to draft. And it's all well and good. That really is the lawyer's job. But it's good for you as a commercial person to know what to expect so you can give your lawyer some guidance what you want to see. Basic thing about termination is some kind of notice. What's a reasonable period to give notice? If the person wants to terminate because of a breach, is there a cure period? So if we have a contract for supply of diesel, let's use our diesel. If I miss the first delivery date, do you automatically terminate, or can you give me notice to say you've missed so delivery? I'm giving you 10 days to meet up with that delivery, otherwise I will terminate. That's a cure period. So it means you have 10 days to cure that default before my right to terminate kicks in. Those are the little nuances you can look at when you're looking at your contract. And then you can decide that certain terms or clauses survive termination. Depending on the nature of the relationship, things like confidentiality usually survive termination. It's not stated, even if you don't state it expressly, things like the dispute resolution clause may survive termination if the subject matter of that contract, something goes wrong even after the end of the contract. So maybe your last supply was on the 10th of December and the contract is supposed to end on that 10th of December. But you supply that diesel and there's something wrong with the quality of the diesel and it now affects all of my equipment and it causes damage to my equipment. The dispute that arises out of that, even though our contract is over, that dispute will still run because it's arising out of that contract. So some things will survive termination. It's just good to know those things. Then subsequently in this training, you will hear a lot about governing law and the dispute resolution clause. The key thing you need to know about the governing law is that whatever your contract is, you need to decide what law is applicable. Usually, if the parties are in the same country, obviously, very likely that's the law you will use. When you have parties across jurisdictions, sometimes they may choose the law of a third country that is neutral, or they may choose the law of either country, maybe depending on where the subject of the transaction is. So where the business is located might be your choice, or you might choose which of the countries has a more developed legal system that can help you with your disputes. The beauty of ADR is that, you know, it does away with some of these things so that whatever your location, once you've picked your governing law, even if you are doing your ADR in another location, you'll be able to, you know, manage how that law affects your disputes and how your dispute is interpreted without having to go to the country where that you've picked as governing law. But if you pick jurisdiction, if you pick a particular country, let's say it's a court dispute and you pick a particular jurisdiction, it means that when there's a court case, that's where you're going to go and resolve your disputes. If you don't physically go there, now that a lot of virtual things are happening, you may have to hire representation from that country. But you will hear a little bit more about governing law when the ADR aspects of this training come up. Then there's the dispute resolution clause. This is where you decide how you want to resolve your dispute. If you don't want to go to court for starters, you will very quickly say that you want to go to arbitration or mediation, or you might even, you know, do it in tiers. We want to negotiate and try to settle among ourselves. If after 15 days it doesn't work, we'll go to mediation. Once the mediation is done, our term of settlement will be binding on the parties, or you go and register it in the courts. I won't go into so much detail about what happens with how the ADR clause is applied, because Mr. Ojo, who is going to do the ADR training after this presentation, will go into those details with you so that I don't preempt him and say what he's planning to say. I've dropped the sample dispute resolution clause, but I'm sure he'll probably have a better sample for you. But those are some of the clauses that you come in contact with when looking at your contract, and you need to bear a lot of what I've said in mind in negotiating and agreeing the terms of those contracts so that you can avoid subsequent dispute as much as possible. And when parties have done that back and forth and they've had that negotiation, it also helps so that the post-contract relationship is seamless. Whoever your business partner is, from how you negotiate your contract, they will see whether you are fair, whether you're rendering your services honestly, whether you are concerned that the product is suited to them, whether you will take care of them if they run into any issues. That helps. Properly negotiated and documented contracts help for good post-contract relationships. And if you add the icing on the cake by choosing ADR, it also helps because a lot of the ADR mechanisms, they focus on building the relationship, preserving the business relationship, as opposed to, you know, just deciding right and wrong and bringing everything to an end. Sometimes that's inevitable, but you will find that these actually help to, ensure that your business relationships last longer. So finally, for your execution, remember we mentioned capacity earlier. Only people who are above the age of 18 can sign contracts, and people who are of sound mind. So once you come to the signature, if it's a legal entity, you will see things like in witness whereof the parties here to have caused their respective common seals to be affixed. Sorry, the language is a bit, what's the word I'm looking for? Is it colloquial or dated? You understand, but there's simple language, there's more simple language for that. The point is, if it's a corporate entity and you have your own separate personality, then you will see things like the parties have caused their common seals to be affixed. If you are entering in your own capacity, you will see things like they within named Mr. XYZ, now hereby executes this document. Then you sign and you provide your date. So it's important at the end of the document to ensure that if it's in your personal capacity, then it indicates that it's just you that is signing. If it's a corporate entity, then you indicate, that the corporate entity has endorsed. That's what the common seal is for, to show that it is an action of the corporate entity and that the person signing it is signing on behalf of that entity. It's good to always know that whoever is signing on behalf of an entity you are going into a contract with has the authority to sign it. So sometimes when you are negotiating your contract, you will see that some of the requirements we need a board resolution. It's very important, because sometimes people can indicate that they have the authority to bind a company and they may not. There are certain instances under the law where even if they don't have the authority, because the authority is apparent to an outsider who doesn't know the inner workings of the company may still be bound. But there will be instances where the company is not bound, and you would have signed all of these contracts for nothing, and you lose a lot of money. So it's very critical to look at things carefully. So before you sign a contract, seek legal advice, read the document, including the fine print, ensure that it reflects the terms and conditions that you wanted. Allow yourself time to consider. Sometimes it's a negotiation trick to tell you that, you must sign it within the next 3 hours because the counterparty doesn't want you to read it. Be careful. Don't be pressured into signing anything if you are not sure. When you are signing a contract, don't leave blank pages or blank spaces so that the page cannot be swapped. Usually the recommendation is that you should initial on every page. So after you've signed at the end of the document, just come and initial every page so that one page cannot be replaced because you've initialed on every page. So it's only the contract that has your initials on every page that's the valid contract. And of course, you should get a copy of the contract for your record, so that I've had instances where people come to me, I have this dispute with this person. We went into a contract for this, and I say, where's your copy? They just gave me in their office, and I signed. I'm like, but I need to see the contract to understand what you signed and what you got into. And it's a hassle because once you've entered dispute, it's hard for you to sort of go back and find a way to collect that document. So those are the key things that I think are important to observe when you're at the early stages of your transaction, so as to prevent disputes. So be conscious of those things. The other thing I want to add, for instance, because of technological disruptions, you will find that sometimes the contracts you are going into, they are not your traditional contracts where you have to sign. You go to a website, you want to do something, and you see terms and conditions, and you have options, agree or do not agree. Once you have to agree to proceed. That does not mean you shouldn't read it, because sometimes when you read it, you will find terms that you cannot live with. Then you may look for an alternative service provider whose terms are different. Because once you click agree, it means that you have agreed to the terms and conditions they put on that site. In the event of a dispute, that drop down menu that says agree or do not agree, that's what's going to govern the relationship. So it's very important, especially for a business relationship, to ensure that you don't fall into some of those pitfalls. I won't dwell long on this one, but the point of this graduating staircase is just to show you that Dispute prevention will cost you the least, so it is cheaper to put together your contract, negotiate it, and close a good contract than to have a bad contract that will give you issues. It's also easy to do your direct negotiations. You may agree in your contract that, oh, the CEO of each company will get together and negotiate in event of a dispute. Unless they can't reach a middle ground, then you escalate. Then you may now get a neutral, whether it's mediation or arbitration, or there's what we call early neutral evaluation, you know, to review your dispute. Or you may have a standing dispute resolution advisor. That comes with some cost because it means you're paying this person consistently. But, well, it depends on the arrangements. But I won't go again into too much details on that because Mr. Ojo will come to that. And then you have your arbitration and your litigation. So it's really up to you how you want your dispute resolved. Usually from industry to industry it differs, and people sort of get a sense of what they need to do. So I'll move on from this point, and I'm gradually coming to the end of the presentation. I don't have a lot more to say after this, but one of the other things that you need to pay attention to apart from your contracting is your compliance. Regulatory compliance is important. Now, I'm aware that in Nigeria, that's a bit of a challenge because there's a lot of, should I say, there are so many regulations to comply with. The system is not properly unified, but it's important. And I've highlighted some of the key regulatory agencies. There will be more, or there will be different agencies depending on your business sector, the nature of your business, and what you need to do. But you know, if you want to have some kind of legal personality, you may want to register with the Corporate Affairs Commission, even if it's a business name, which is not separate from you. But at least it's a name that you can trade in. You can still register that with the CAC. But those come with minimum requirements. You need to file annual returns. That means you need to keep your books. You need to be able to say on a year-on-year basis, this is the value of my business. You know, you need to file those returns with the CAC so that they know you are in business and this is what you are doing. You need to register with the tax authorities. It's very important. And I say it's very important because even though our tax system is not very efficient in chasing down people who have not paid their taxes to pay their taxes, as a small or medium enterprise, what you want to do is be compliant in the event that you need to bid for certain kinds of jobs, or you need to apply for certain sorts of grants or funding. There's so many reasons why your books need to be in order, why you need to keep good records, why you need to file your returns as and when due. And I don't think these things cost a lot. The Federal Inland Revenue Service will assess your tax based on profits. So if you keep your books properly, you've got a good tax advisor, and you know, you separate your income, your profits from your revenue, you'll be able to tell what portion of your income should be taxed. And it's only good record keeping. One of the mistakes that most small businesses do is that they don't draw the line. So if they don't draw that line, it becomes difficult. It becomes difficult to rightly assess if they are making a profit or not. So there will be little expenses that you may not account for. Once you've accounted for the value of the goods, you've accounted for the logistics, you don't account for other things. If you run a generator at your premises, you don't account for that. If you spend your airtime to do business calls, you don't separate it and account for it. Those are all your expenses. And you need to be able to separate your business expenses from your personal expenses so that you can back them out of your business expenditure and leave what is really truly just your profits. That's what the government can tax. If your books are properly done, you will find that you will save yourself a lot of money in taxes. So it's very important. Depending on your business, you will need licenses and registrations, trademarks, NAFDAC, SON, copyrights. It depends on the sector. It depends on the structure of your business, and it depends on the activity you're carrying out on the marketplace. For every kind of business, it's easy to find out those licenses, permits, authorizations that you need if you speak to the right consultant. So I will recommend, as much as possible, find affordable consultation that will meet your business needs. I won't go into details of all this. What I would add, I had added some bonus slides and I won't go into all of them, but I'm just going to flash one to show you that technology has disrupted the way law is practiced now. So legal service delivery is largely commoditized. It means that you can find it online. Because it's commoditized, it's already pre-prepared for you. It's affordable and it's easy for SMEs to work with. There's a bunch of other legal service providers that I've listed somewhere in my presentation. These are just to give you direction where to look in case you are looking for legal representation that will help you cover some of these things, but will not bore holes in your pocket. That's one way to go. Find a legal service online that will give you pre-drafted contracts, but can review them to customize them for your needs. Meaning that if you find a pre-drafted agreement, but there are some things that don't work, there's the option for you to call and speak to a lawyer and adjust them. You will find that some of these services will cost a fraction of what it will cost if you walked into a traditional law firm and said, I need a lawyer to draft this for me. I'm not trying to demarket any lawyer. I'm one of them, and I work in a traditional law firm, but if you're looking for something affordable, it helps to go with the pre-packaged products because they've been pre-packaged and they're sold to a wider audience. The lawyers delivering those services are able to give it to you at a very reduced price. So that helps you to manage your financial outlay for documentation purposes and for compliance purposes. I think, having said all that, I can skip to the last slide and say thank you for listening.
Thank you, Laura.
Thank you.
So I think we should still be able to take 2 questions.
Okay.
So there's one that I saw on how do you enforce an oral contract when there's no evidence that you entered into it? And the person has provided an example that when you rent an office space and the agent says you can use certain facilities and comes back to say to rescind or go back from such agreement, that how do you enforce the contract when it's not written? Do you want to provide a quick response to that?
Yes, I would like to provide a quick response to that. I would start by saying very carefully that typically contracts that have to do with, or transactions that have to do with property, typically should have written contracts. So you would want to, in the first instance, as much as possible, avoid an oral contract for the lease of a property. No matter how basic it is, my first recommendation, this is for dispute avoidance purposes, is to avoid an oral contract that has to do with property, so that you don't run into these issues, because you'll be living in the property and there's a variety of services you may require. There's a variety of activities that the lessor will not want you to do in their property. If it's not written, it will be difficult for either party to establish that, oh, this is what we agreed. So unless you have some form of evidence to show that this is what your oral contract contains, it will be difficult to prove it. The oral contracts that are easy to enforce are the ones that, they are ones of general usage that the implied terms are pretty clear and obvious. Those are easy to enforce. But for something like a lease agreement that is not normally oral, it's usually in writing, it will be difficult to enforce an oral. So please, as much as possible, put your contract in writing. And sometimes it helps. And I'm not saying this is not ideal, but where you don't even have a signed contract, if you have written records of your communication or correspondence on those things, it might help your case. So if you have email exchanges, WhatsApp exchanges, text messages that you've exchanged to say, oh, I'll do this for you, it helps. That may be one way that you can establish your case.
Thank you very much. Just on the final note, do you want to quickly speak to the question of force majeure and whether COVID-19 will constitute a force majeure event?
Right. This is an excellent question, and it's the question of is the question of the year. In all of this COVID period, we have seen a lot of issues around force majeure. Personally, I've seen a lot of back and forth movement between parties when it comes to force majeure. Force majeure is generally something that the parties could not reasonably envisage, which serves to suspend their obligations in a contractual relationship. And because they could not reasonably anticipate it, for a duration, you can suspend those activities until some kind of normalcy is returned. Then your business can carry on. Now, COVID-19 would probably be force majeure if it fell into the scope of how your force majeure clause was drafted. The challenge with the COVID-19 is that most people didn't anticipate it. So when they drafted their force majeure clause, they gave a list of the kinds of incidents that constitute force majeure. And COVID-19 was now not one of them. So it now became a question of, oh, is this force majeure? Is this not? And it's a bit nuanced. So depending on how your contract was drafted, that would help you to determine whether you can really say that force majeure, that COVID-19 constitutes force majeure. But COVID-19 is a global phenomenon. So in spite of the contract, you will find in some instances that people are able to still suspend the performance of contracts despite the way their force majeure clauses were drafted. And then for those that didn't have force majeure, fortunately for them, then the doctrine of frustration could apply to say, you know what, the pandemic has frustrated my ability to perform this contract at all. So, you know, in this instance, it can actually bring the contract to an end. But again, it depends on the circumstance of each case. So the short answer to that question is, it depends on your contract and the circumstances of your case.
Okay. Like my friend will rightly say, a smart way for a lawyer to end every conversation is it depends. Thank you very much,
Yes.
Laura, for that very informative and educating session. Thank you. Just to note that if any of the participants...
Thank you so much, Abayami, and to all the participants.
Thank you. So if you have any question, and if you think you have a question that has not been answered by Laura, please send those questions to info@pensburylaw.com, and then those questions will be answered. Then just to also note that the Pensbury attorneys and solicitors, my understanding is that they also have dedicated SME services. So if you have issues with your contract, you want to draft contract, you want to do things relating to ADR, you can also reach out to Pensbury attorneys and solicitors, and they'll be able to help you with that. Moving swiftly to the next section, because we already have Mr. Ojo join us from the beginning. Mr. Ojo is, what I will refer to, or who I refer to as one of the, major experts, ADR experts in Nigeria. It is such a privilege to have him join us today. I will just quickly give you, a brief, background of Mr. Ojo. Is a legal practitioner and senior partner of SO&C Legal, a law firm based in Lagos. His experience cuts across transaction, documentation, litigation, and ADR, particularly in the areas of corporate, commercial, and international business law. He has attended and distinguished himself in courses both locally and internationally. He's an alumnus of the Academy for American and International Law, where he attended as a recipient of the 2004 Victor Folsom Fellowship Scholarship for Africa. He has also appeared before the various tribunals, both private and governmental, as well as trial and appellate courts in Nigeria. So Joe is a notary public for the Federal Republic of Nigeria. He obtained his bachelor's degree from, they call it Great Ife, Obafemi Awolowo University, and Master of Laws degree in International Business Law from University College London. We share alma mater. He holds 2 international business practice diploma in international business organization and international M&A, respectively, and STEP advanced certificate in trust creation, law, and practice. Well, this profile is long. You have his profile inside the brochure. You can read it up later. But it's my pleasure to welcome Mr. Ojo to take the next session on understanding ADR and processes, focusing likely on negotiation and mediation. Mr. Ojo, you may have the floor now.
Thank you very much, Abayomi. Good afternoon, good morning, ladies and gentlemen. I thank you all for the opportunity to speak to these issues this morning. As Abayomi has said, alternative dispute resolution has become key in the business space for resolving commercial disputes. You all are representatives of SMEs or working with SMEs. I imagine that in the audience, in this virtual audience that we have, we don't just have SMEs, we also have micro enterprises there. So you can imagine what it would be like if you want to resolve a dispute and you have to expend so much to resolve very little. So my best explanation is like eating crab. When you put a big chunk of the crab in your mouth, you crack into it, the weight with which you break into the crab cannot compare to the little that you're going to get out of it. So it's a lot of work done, a lot of expenditure done, but very little that we have gained. So I will be speaking to the issues of alternative dispute resolution. And the focus of my own presentation is just going to be alternative dispute resolution with reference to negotiation and mediation. Now, we'll of course look at the forms of alternative dispute resolution. What exactly is alternative dispute resolution? Well, I'll veer into negotiation and mediation, and then talk about the nuances of mediation, and then we'll close up there. Now, I should caution that what I will be talking about for the most part have to do with processes. What I'm hoping that I'll be able to achieve through this exercise is a situation where I would have succeeded in discussing areas that you can readily relate with, things that you would have experienced on a normal day, on your normal day-to-day experiences, whether you're entering into a contract or whether you are in any form of dispute whatsoever. So it'll be more of processes. Like Abayomi had cautioned earlier on, I will take questions after so that we do not stop the flow. But I'm hoping that I may be able to hold your attention through this next few minutes and then talk to these issues. So you are looking at a slide now that talks essentially about what exactly conflict is meant to be. Peace is not the absence of conflict. It is, however, it is the ability to handle conflict by peaceful means. Now, there are different variants of this quote. This one is by Ronald Reagan because I think it is very well suited to the purpose of our discussion. And why do I say so? We all are in one form of dispute or the other in our normal day-to-day routines. So how do we resolve it? What exactly is this peaceful means? And this is where we come to the concept of alternative dispute resolution. Alternative dispute resolution is any procedure, I'm being very brash here, but any procedure for resolving disputes without litigation, without going to court. It is not because judges are bad. It is not because the court is a bad place to be. No. But sometimes there are some disputes that we need not take to that forum. In my day-to-day practice as a lawyer, I practice as a negotiator, as a mediator, and as a litigation person. I sit very often as an arbitrator. So what this has done for me over the years is that when somebody sits in front of me, I am able to a fine degree to assess which dispute resolution process I think is better suited to that person's needs. Note what I'm saying. I said better suited to the person's needs. What exactly does the person need from the process? And I'm able to advise on that. So we're looking at processes outside litigation. Now, but then we must understand what we are taking to that forum. What are we taking to that forum for resolution? That is what we call conflict. If you go back to the definition we just talked about now, we're talking about alternative dispute resolution being a process by which we resolve conflicts or disputes. So what is that thing called conflict? Because I think very often we get it wrong, or even if we get it right, the way we behave towards conflict is often what gets us into difficult times and murky waters. Conflict is inevitable, but combat is optional. I tell people that it is my prerogative to be unreasonable. So if you're telling me something that is reasonable, if I do not agree with you, or I know what you're telling me is the truth, but I choose not to agree, then I am totally being unreasonable. But then it is my prerogative. You cannot arrest me for being unreasonable. Yes, I will face the consequences of it eventually, but you cannot arrest me for being unreasonable. So my point is, if I choose to fight you, it is my option. I will face the consequences of it. But what are we talking about here? As business people, as men and women of commerce, as business entities engaged in commercial activity of any type, we cannot but find ourselves in conflict situations. So the question then is, what do we do? What choices do we make? And I make a distinction here between conflict prevention and conflict avoidance. I was happy when Laurel said, dispute prevention will cost you the least. The least. I mean, I took that away from Laura's presentation. There's a difference between preventing a dispute and avoiding it. The very essence of what Laura has just taken you through is conflict prevention. So party A knows what his rights are, party B knows what his rights are right from the beginning of the contractual relationship. Somebody asked a question that I thought was rather odd. When do you negotiate a contract? That question is odd. Why do I say it is odd? Because frankly speaking, you shouldn't enter into a contract without negotiating the contract in the first place. You cannot put the cart before the horse. So conflict avoidance, however, is a different thing. Conflict avoidance comes up when you are trying to be nice. You don't want to hurt the person's feelings. You're trying to avoid confrontation. That conflict avoidance is a problem because that problem will never go away. It will never go away, and one party will always feel ultimately like a doormat. So yes, while you encourage conflict prevention, conflict avoidance is a totally different kettle of fish. You don't want to go there because it is going to cost you a lot more. Now, the question is, what are the forms of alternative dispute resolution? We're not going to go into all these forms, but it bears relevance to mention these forms to you to at least bring some context to what we're talking about. Negotiation is what you normally would do. In fact, to be honest, when there is a dispute, the default mode of the average business person is a negotiation. You call the person, come, I told you to do this. Why did you do this? Why did you go this way? Oh, I asked you to supply this. You have supplied the wrong thing. How are we going to sort out this thing? I'm not going to take this. I'm not going to do that. I'm not going to do that. The truth be told, when you start that process of conversation, what you are doing is negotiating. It sounds funny, but in a minute, you will see what kind of negotiation you were actually engaged in when you were doing that. But negotiation is the very first port of call. It is perhaps even the cheapest. Then mediation. Mediation, put differently, as we'll come to find, is assisted negotiation. The difference is that some third party comes in to assist you, assist the parties to negotiate. Why will the third party come in? How will the third party come in? We will deal with that very soon. Then arbitration is the next one. Arbitration wears the semblance of litigation. However, it is less formal, it is more consensual, it offers more benefits. That is an area where Fumi will discuss with you tomorrow. But it is a form of dispute resolution. It wears the semblance of litigation to the extent that there will always be a winner and there will always be a loser. Because when you negotiate or mediate, the decision ultimately is the decision of the parties. But when you go into arbitration, both parties have not been able to reach any compromise or any agreement. So you are leaving it in the hands of a third party to say, you judge it and decide for us. What do you think from what we're seeing here? So that is an arbitration. The only difference, and you'll get more from that tomorrow when Fumi speaks to you about it, is that arbitration is not a court, it is less formal. And it only arbitration, as indeed negotiation and all other ADR processes, have the advantage of enabling you as parties in disputes to choose who decides your dispute, how your dispute is decided, where your dispute is decided, when your dispute is decided. Those are the main features of alternative dispute resolution that are fantastic sells for the process anywhere. Now we have conciliation. Now conciliation is similar to mediation. The only difference is this: the conciliator takes a more proactive stance. A mediator is assisting both parties to come to a decision. The decision is the decision of the parties. He's not going to recommend anything to them. What the mediator is going to do is to skillfully try to bring out of the parties the actual thing that will drive the process. There is a saying that the devil is in the details. Those things that never find their way to the black and white of your contract documents are the things that drive the contract. That is what the mediator is trying to get into so as to get the parties to come to an understanding. The conciliator may do that, but the conciliator takes a more proactive step by even recommending sometimes that this is the way. How about doing this? He sees it as an obligation to make sure that you reach an agreement, which is not the remit of the mediator. Med-Ab is a fusion of mediation and arbitration. It is very possible that parties begin to mediate the dispute. Maybe there are about 5 issues that you want to contend. However, you can only succeed when mediating. You only succeeded on maybe 2 out of the 5. But you resolve that the remaining 3 should be dealt with by the neutral third party who will hand in a decision. And lastly, there is early neutral evaluation. You can find this mostly in construction industry. You know, when you're having a construction work, an ongoing construction work, you cannot tie down money to go for 6 months, 5 months, 10 months, trying to resolve the dispute. So very often you call a neutral, who often is an expert. Maybe it is an architectural issue, maybe it's an engineering issue. The expert takes both sides of the divide, looks at it, does an evaluative process, and tells you the way to go so that the contract can continue seamlessly within a very, very short time, so that you don't have the downtime expenses that will come on account of maybe delays on projects and all. If you look at a typical construction site, you have a payloader, which you are paying for every day. You have equipment on site which are being paid for by the day. So the shorter the time to resolve a dispute that emanates in that context, the better for you. So we're talking negotiation and arbitration in this presentation. What is negotiation? A dialogue between two or more people or parties that is intended to reach a beneficial outcome. A mutually beneficial outcome is what I should have put there. A mutually beneficial outcome over one or more issues, wherever a conflict exists in respect to at the very least one. You remember I just talked to you now about MedApp, where sometimes you have just one issue decided upon while the others remain outstanding. Mediation is a process in which a neutral third party assists disputing parties to work towards reaching a negotiated agreement in settlement of a dispute. Take note, a negotiated agreement, which means that the mediator is coming in to facilitate negotiation. It is important for you to bear that in mind. The mediator is coming in to facilitate negotiation. So, when I spoke a few minutes ago, I talked about a dispute coming and the man picks up his phone and he says, look, why did you do this? Why did you do that? And I said to you, I said, what you're actually doing is negotiating, but what form of negotiation are you doing? Now, in this book, I met this gentleman sometime in 2004, and he taught me on a course in negotiation and arbitration. And he had just written this book at that time. And it was a very profound book because he identified three models: negotiation as a compromise, negotiation as domination, negotiation as joint problem solving by both parties. Let us look at these models and talk about them. Then you'll be able to say, which one do you think you were deploying at that time? And perhaps if you should have used another model, maybe you will now, with this opportunity, imbibe that model, learn that model, and learn to apply that model. The first is negotiation as a compromise. It's identified as distributive bargaining. One thing I want you to notice about it is that it has a win-lose to it. It has a win-lose. That means you gain one, you lose the other. I'm sure most of us have had expressions where you win some, you lose some, you win some, you lose some. So basically what it is that it assumes that both of you have, and I'm using two parties for an example now, have irreconcilable goals. Your goals are not compatible, but both of you have resolved that you have to negotiate and reach a compromise. So what do? All right, I will leave this one. You will leave that one. I will leave this. You will leave that. I will leave this. You will leave that. And then you now come to the one that both of you can agree with. The point about the losing, yes, you would win to the extent that you get value. You reach a decision that has arisen through the negotiation process. However, there are still some things that you've had to lose in the process, which again is just a model. Sometimes it works well, sometimes it doesn't work well. You're trying to divide just that one single fixed pie. And to get to divide it, both of you make concessions. So what other model do we have? Negotiation as domination. So the man that grabs his phone and begins to rain insults, he's negotiating all right, but sometimes, and as in most times, he's perhaps trying to dominate the other person. And all of us, including me, yours truly, we've been in situations where you have the upper hand in a negotiation and you are forcing something down the throat of the other man. That is what negotiation by domination it deals with. So you have it sometimes as business people, maybe you're providing service to a big entity. So let me give an example. Maybe you're a catering company that is providing services to an airline. The airline, you begin to perceive they have very many options available to them. They don't have to use you, so you have many options available to them. But you're in a negotiation with them and they're telling you that we're not going to take this from you. We're going to remove you from our list of caterers, you're not going to supply us again. You must accept this is the best we can do for you. And you have that sometimes, even when that party is the one in default, but is using his clout to negotiate. So ultimately, you find a situation where that party takes the bigger chunk, if not all, of the fixed pie. That is what happens in negotiation as domination. Like I said, it's a variant of the first model because you're going to have to be forced to make concessions. And you're obviously making losses in the process of making those concessions. The only difference is that while in this one, there isn't a balance, in the other one, there is a fair balance, and both of you actually come to that agreement mutually. You have an understanding. The third one is negotiation as joint problem solving. Now, this is a very interesting one, and this is the place that most business people are encouraged to go to. Let me tell you something, listeners. It's very possible, whether you like it or not, to find yourself in a courtroom. Sometimes you'll be sued when you shouldn't even have been sued in the first place. Under the rules of court, there is something called asking the courts to throw out the case because it does not disclose anything reasonable against me. Now, you can ask the court to do that. Your lawyer can ask the court to do that. But the fact of the matter is that you still have been taken to court. You have also have to bear the cost of the lawyer. So there will be some times where unreasonable things are thrown against you. Now, that is something that is inevitable, especially when you're dealing with negotiation as domination. But where you're dealing with negotiation as joint problem solving, the key features is that it is interactive and interest-based. What do I mean by being interactive and interest-based? So sometimes what you're seeing on paper is one thing. What is driving the entire dispute resolution process is a totally different thing. In this model, what is happening is that parties identify, look, we are where we are. There are problems. This is a problem we have to take as our own problem. So they see themselves as, they see the problems as their joint problems. Even if it is more weighted towards one than the other, that other will try and see how best to manage the situation so that that other person will be alleviated, such that he also will get some alleviation in the process. It looks at interests. Those goals, they are not incompatible. They start with a default mode that, no, we're looking for the same thing. It is not incompatible. The discussions we want to do here, we're not incompatible in terms of our interests. Yes, it might be A, it might be B, but they are not incompatible. But even if on the face of it, they are not incompatible, it does not mean that they cannot coexist. So we can have different interests, but they can still exist together. While we're pursuing our respective interests, we can actually work on this contract and get better value for the relationship. So what do? They try to arrive at a deal that integrates those interests into a well-crafted agreement for them. That is what negotiation as joint problem solving is. This model is actually the model that is best encouraged, because in that first two, insofar as they result in a win-lose, somebody is going to be thinking in his subconscious about the fact that he made a loss. He made a loss. He made a loss. He does not want it to occur again. He made a loss. And I'll give you an example. You have two children, and this is a true story that happened many years ago. So you have two daughters of a very rich man to whom he had given his estate. They implemented everything in the will. Both of them got the value they wanted for the estate. Everything was sweet and normal, except for one thing. Their father had a ring that he did not talk about in his will. And so both ladies went into dispute over who is going to get that ring. So the one said, no, I should have it. I was the one who was closest to him in his lifetime. I took care of him. The other one says, no, I should have it. After all, we're both his children and I'm older than you. So why should you have it? What is it that you have that is different from mine? And that caused a lot of bad blood. Until one of them woke up one day and said, hey, what am I thinking? This is my sister. Why don't I work with her on this? Because we have a father. We had a father that loved us both equally and provided for us equally. So she grabs the phone and calls the sister and says, ask the same question. Why do you want this ring? And you'll get to that when we talk about communication. And she says, look, I want the ring because I like the gold, the diamond thing on it. That's the only reason she wanted the ring. Oh, that's why you want the ring? Yes, okay, you, why do you want the ring? Well, I just want the ring because it's just a sentimental thing for me to remember Daddy by. And that's how they were able to do it, because the person that wanted the pendant got the ring, got the pendant off the ring, while the person that wanted it for sentimental value still got it and went to put the pendant on an old ring she had and got the jeweler to put it there. That is what, when you deal with negotiation as joint problem solving, that is the kind of result that you get from it. And that is what in negotiation terms is called principled negotiation. It is an interest-based approach to negotiation that focuses primarily on managing the conflict and conflict resolution. So the principled negotiation uses in the integrative approach to finding mutually shared outcome. What are the foundations? Separate the people from the problem. My sister is not my problem. There is something bigger. Let's look at what exactly we're fighting over. Let's focus on the subject matter. Focus on the interest, not the position. I am the oldest and therefore I must get it. No, it doesn't have to be. Oh, I have more clout. I have more clout in this place, so I must get the bigger chunk of the deal when the profit comes. No, not necessarily so. Because when you have money to put down, somebody might have capacity to make that money earn bigger money for you. So the mere fact that you have cash does not of itself mean that you have the all in all, because everybody brings something to the table. Invent options for mutual gain, which is what these girls did. Invent options that will be more beneficial to both of you. And then insist on an objective criteria. Insisting on yourselves applying objective criteria, basically saying to you, okay, what would be the norm? What's be looking at? Is it your standard or my standard, or a standard that will be beneficial to us both, that is independent of us? That standard might be well higher than the standards you both have, or might just be there. But what ultimately you're doing is that you're not focusing on the people, you're focusing on the interest, you are creating options, and then you're using an objective criteria to do it. So, like we said, you have negotiation, and then you have mediation, which is assisted negotiation. So let us prepare for that negotiation. We are in a conflict situation, and that conflict has come. We need to resolve that conflict. Excuse me, please. We need to resolve that conflict that has arisen between the two of us. How do we go about it? The first thing we've got to learn about it is our attitude. The man that grabs the phone and speaks brashly at the other person, even if I am wrong, I do not want to be insulted. And one of the favorite examples I give, forgive me if it sounds very sneaky. If you see a snake, a deadly snake, in any place, and you're walking, instinctively, the thing the snake does is that it runs away from you. The snake runs away, regardless of how poisonous the snake is. But you push that snake onto a corner, and it turns back at you and is ready to fight you. So even if I am the weaker person, the last thing I want is for you to be insulting me. So what am I saying here? Your attitude is key. Because whenever you're in a conflict situation, there is one factor that can make the difference between damaging that relationship and deepening it. When you raise your voice at the person, you think they are trying to keep that relationship or get him to do it right. You cannot force me. Again, it goes back to what I said earlier on about being unreasonable. It's my prerogative. You can't force me to be reasonable with you. If you talk to me, as we often find in mediations, if you speak with me in a wrong way and you rub off wrongly on me, because of that, you might get a deadlock. We'll talk about that in a minute. I just would refuse to budge, even when I could do it at no cost to me at all. So your attitude is important. That factor is the attitude. John Maxwell says that your attitude is what determines your altitude. How well you will fly determines on the attitude you deploy. So how do we prepare for a negotiation? First of all, determine your goals. What do you want from it? Is it just a contract, or do you want the relationship? Sometimes some contracts are long-term contracts. They are not just buy and sell. Some people have relationships with companies such as Cadbury, Coca-Cola, that every quarter they get LPOs from them for supplies of items. You want to preserve the relationship. I'm sure some of us have been to entities where you're trying to put in a bid and somebody will tell you that, no, sorry, we have only these companies. That's because those companies have built a reputation over time. So that long-standing relationship, is that what you want, or you just want to sign a contract and go? Look at the people that are going to participate in the negotiation with you. If you want to negotiate with somebody, ask yourself, is Mr. A or Mr. B necessary? Sometimes it's not necessary for you to take your lawyer. Sometimes it is not. Sometimes it is necessary. But you need to ask yourself, you are the one that knows the person you're negotiating with. You know the peculiarities of the circumstance, so you decide who and who will go with you. Begin to define your interest and think about the interest of the other side. There's no point going into a negotiation talking about yourself without knowing what the other side wants. You've got to know what it is that makes that other side tick. Why are they reacting or conducting themselves that way? You want to do some research. Identify what issues are there. Determine your best alternative to a negotiated agreement. We're going to talk about that imminently. Very soon, we're going to talk about that. It's called the BATNA. But put differently, what is the best you want to get from the negotiation? And if you do not succeed in getting a deal, what is the best of the options open to you? Remember, we talked earlier on about you inventing options for mutual gain. So out of that option, or those options that you invented and have explored, which of them is the best? That will be your partner. Research the other party and the deal. I just alluded to that now. Look, today we are in the days of social media, the wonders of Google, I call it. If I'm having a meeting with somebody I don't know, or even if I know the person, I will do a search, a Google search on the person. I will do a Google search on the person. Pictures tell stories. There are some people on Facebook. There are some people, businesses on Instagram. So you go and look at this. It's part of the research. Find out a lot about that person to be able to talk to that person. And I'll give you a quick example. Many years ago, I had to cross-examine somebody in court. This is court now, not ADR. And the person is an expert. And I thought to myself, is a forensic expert. I didn't know how or where to start from. It is not a subject I went to school to study. So how will I cross-examine the thing? And I knew the man was coming to lie. So what did I do? I went on Google. I Googled the man's name. It came up. It gave me a list of cases where the man had testified and that his cases had been up, his testimony had been upheld. That didn't make me feel good because I was looking for something to show that is a liar. Then I refined my search and I said, this man's name with evidence rejected. Oh my word, I saw something beautiful come out of it. I saw something beautiful. I know no matter how pitch, no matter how dense darkness is, if you strike a match, where that match is, there will be light. And that was what I used, and it availed me. So my point is, look and do your research on the other party, not because you want to be able to bring them down, but essentially because you want to know how to connect with them during the process of negotiation. And as we said earlier on, formulate mutually beneficial options. So what is your BATNA? Your BATNA is the standard against which any proposed agreement should be measured. You will understand more what I mean by that very soon. Because what we're talking about here is you're going to an agreement. You must have anticipated something. But don't go without inventing options. We'll come to that now. That's the next slide. You will understand it fuller. Next slide. But what your BATNA does is that it provides a balance between two things. If you do not prepare for a negotiation, if you don't prepare properly, you are likely to reject an offer that you should have accepted, or you may well end up accepting an offer that you have rejected. But if you follow up on the proper preparations, which is what I talked about before, they form part of your processing your BATNA, you will find out that it is not likely that you will reject an offer that you ought to accept, and it is also unlikely that you will accept an offer that you should have rejected, because you have a holistic view of everything that you need. Your BATNA versus your bottom line. You know what your BATNA is. Your bottom line is your reserve, something below which you will never fall. But some people call it WATNA. That is, as opposed to when one is the best, the other one is the worst. So what is the worst alternative to a negotiated agreement? So you look at those options that you invented. You have taken the best as your BATNA. Clearly, the least likely that you are going to take will be the worst of those options. So that's your WATNA. So how do you develop your BATNA? I put a note to self. Remember always that the purpose of negotiation is for you to have a result that is better than that which would have been the case if you did not negotiate. Think about that for 5 seconds. A result that will be better than the one you would not have had, than what would have been the case if you did not negotiate. That is why you want to go negotiating. So if you fold your hands and allow yourself to be a doormat, simply because it's a big entity fighting you, a small entity, or even if you are the big entity, you refuse to negotiate because you are all in all, and we get that a lot in our environment, you may find yourself in that situation where you will accept an offer you should reject, or reject an offer you should accept. There are ways to deal with big entities, but that will come in the course of the paper. So how do we get our BATNA? Like we said earlier on, invent and consider a list of available options you might take in the event that there is no agreement. Invent a list of options. There will always be options. Even if that option is no option, there will always be an option. So let me look at those options. Let me list them out. When I've listed them out, the next thing I want to do is let me see and analyze those options, improve on some of the more promising options that come up. You see, what the first step does, which is where your BATNA is relevant, and we'll see the value in the BATNA very soon, is that it gets you to think deeper and deeper and deeper about the problem, about what you want from the process, and about how you're going to go about the process. When you are improving on that option, you can see whether your case is totally bad, or actually it is brighter than the world makes it look for you. And then at the end of the day, select the option that is the best of them all. That, ladies and gentlemen, is your BATNA. That is the option that is the best of them all. So what is the value that you have in your BATNA? Number one, it is a realistic, you cannot but have a realistic assessment of the consequence of your failing to agree. So if you don't agree, you know what consequences lie in wait for you because you have evaluated all the options open to you. Your partner builds confidence. It builds confidence in you when you are going to negotiate. Because if you are looking at the options available to you and you see that it's not so bad, there's a place you can go if you don't agree with this man. Then you have a stronger leaning towards speaking boldly about the issues. Then it helps you when you are putting together the kind of offer you are going to make to the other side. Then it can also help you to determine whether or not there will be a deal with the other side. In fact, you will know more about how far the other side is willing to go. And I'll give you a story. In fact, let me end by saying it defines what you call an amicable and efficient settlement. Let me tell you a story, and this is another true story. I think it was in the year 2000. I read this many years ago, when most of us will know the company Daimler-Benz. Daimler-Benz are the makers of Mercedes-Benz. Daimler-Benz merged with Chrysler, which is another company. Now, what happened was that the market was competitive. Mergers were the way to go. Mergers had become inevitable. So Mercedes-Benz was in talks with Chrysler about merging. They were driving a very hard bargain and they couldn't get anywhere. And it had reached the point where Mercedes-Benz had its back against the wall. It is a very good brand, but Chrysler was going stronger on the negotiations. Then the chairman of Mercedes-Benz, the man's called, I think his name is Jürgen, I can't for the life of me remember his name now. He then realized that, look, hey, we did our research. Now, in their own research, they found out that while Mercedes-Benz, while they were in talks with Chrysler, they were also in talks with Ford Motors. So they had other potential partners, but Chrysler had no potential partner at all. Meanwhile, Mercedes-Benz wanted to merge with Chrysler. If they succeeded in that merger, literally, Mercedes-Benz would be the stronger partner, while Chrysler will be swallowed by Mercedes-Benz. However, the option open to Mercedes-Benz, which is why they were discussing with Chrysler, is that if they had merged with Ford, there was a possibility that Ford will swallow up Mercedes-Benz because that would be a more dominant partner. So it was the best alternative they had to a negotiated agreement because they still had merger talks ongoing on the side. However, they wanted Chrysler. So at that point, they decided that, oh, well, should we disclose? Because that's one of the things you're going to also learn in another slide now. Perhaps now that we're at this point, we need to disclose those points to them. So they told Chrysler, look, hey, if you don't agree with us, we have this option, but we would rather go with you. Now, that immediately turned the tables because Chrysler knew it was in a market that was strong and heavy and the competition was rife and it needed a merger partner. And that was how Daimler-Benz took over Chrysler. I'm sure most of you hear of Daimler-Benz. You don't hear of Chrysler today. So that is the power in your partner. That is the power that lies in your partner. So when we go to the desk and we try to negotiate, what are the things that we need to be mindful of? Number one, communication is key. Again, that man picked up the phone and was raining insults. If he had spoken better, it may have been different. Now, listen attentively. Listen to understand and be active listeners. Don't listen because you are just trying to wait for him. Okay, let him just finish. I know what I'm going to tell him. No, listen so that you will pick where the person is coming from and you will understand where the person is coming from. Acknowledge what that person is saying. Don't interrupt. Because when you interrupt, it shows that you're not listening to me and it is rude. When you are called upon to make an offer, don't make an insulting offer. Make your offer something that is close to your zone of possible agreement. We will talk about that next. A zone of possible agreement. Use it as your benchmark. For every negotiation, there is a zone of possible agreement. Just hold on to this thought We'll get to that slide next and we'll talk about what that is. Speak so that you can be understood. There is no point in both of you talking over your heads. One. Number two, we often are abrasive. We talk at the other person rather than speak to the person. We talk at the person. We're rude. We're very insulting. The man will say, how can you do this to me? Blah, blah, blah. And this is a quote I found, which interesting. 10% of conflict is due to the difference of opinion, while 90% is due to the tone of your voice. If you raise your voice, even to your friend says, why are you shouting at me? Even to our spouses, why are you raising your voice? Can't you just talk to me gently? Sometimes because of the attitude you deploy, you get the wrong answer. Don't insult, don't engage in name calling. Create an enabling environment for negotiation. I told you earlier on, sometimes you don't need the lawyers. The lawyers have been in mediations. I cannot go, maybe during the Q&A, I'll talk about it. But you sometimes have situations where some people being in the room make it impossible to really negotiate. And those people, I'm not talking about lawyers alone. It can be anybody. I may not want to speak openly in front of this man who is an architect on the construction site. Maybe because I know there are certain things that have gone on before. So be sure to make sure that every person who is there has a key part to play. Speak about yourself, not about the other side. That's a way of cautioning yourself when you're speaking to the person. Let the other side also understand how you feel. Because when you are listening actively to understand how that person is feeling, to understand where that person is coming from. It stands to reason that you also want him or her to understand what you're feeling and where you're coming from. Speak for a purpose. Don't just be flippant about things. Don't over-communicate. You don't have to tell everything out there. Speak only to that which is relevant. The chairman of Daimler-Benz waited till a particular point before he brought the cat out, let the cat out of the bag, before he brought out his own joker. And that was because he wanted to swing the negotiation. In fact, that piece is titled Taking a Ride, How Daimler-Benz Drove Away with Chrysler. That's the title of that piece. So you have to be strategic. That's what it basically means when you are talking about it. So I talked about the zone of possible agreement. This is a bargaining range in an area where two or more negotiation parties may find common ground. So let me explain this map to you. So on the right corner here, you see $10 million. And I'm using dollars because I'm saying this is an international conference. I'll just use the figures. And here you see 6 million. Below here, you see 8 million. And here you see 4 million. Now, this blue line here is the seller settlement range. So the seller has come and say, I have this car to sell, or I have this house to sell in Banana Island. Now, my asking, this 10M is literally what you and I in common parlance will say is my asking price. However, I will not go below 6 million. On the flip side, you have a buyer who wants to buy that property. His budget is 4 million, but he says he will not go below above 8 million to buy that property. 8 million is the maximum that the buyer is willing to expend to buy that property. Where is the zone of possible agreement? It's somewhere between here and here. That is to say 8 million minus 6 million. So you will find out that you are working between, so any deal that falls from 6 million to 8 million will typically be beneficial to both parties because each party would have got value for their transaction. It will not be a win-lose. It will be a win-win. But you can only have a ZOPA where there is an overlap. Without an overlap in expectations, you will not have a ZOPA. So when you are going to make your offer, as we had just talked about, try and make your offer as close as possible to the zone of possible agreement. So in this transaction, if you want to make an offer, maybe you want to start with 5 million. You want to make an offer for 5 million, and you can start from that. So that is one of the things. But the thing that your partner, preparing your partner would have done is that in the course of the discussions, you will come to an understanding of what the ZOPA is. So when you're going to make your offer, you are try to start from it. Don't start from 4. Because before you left your office, you were saying that 4 is what you want to pay. But when you started having this conversation, and with all the conversations that have come, we have realized that there is actually a need for you to increase and improve on it. But still, you want to work within a particular zone. So when both of you negotiate, that zone of possible agreement, anything between 6 and 8 million stands to be something that the parties will find mutually beneficial. A quick inroad into mediation. Now, you will find out that in negotiation, because the parties are dealing directly with themselves, it is not unlikely that they will get emotive. Again, I talk about the man that picks his phone and rains all manner of insults. It is not unlikely that things will get a bit tight and upsetting. So how do you resolve this? The best way sometimes is to get that neutral third party called a mediator. That mediator is one who would have imbibed all the virtues that we have discussed and use his skills to deploy those virtues in getting the parties to an agreement. Mediation by its nature is an assisted negotiation. So what the mediator tells you when you go into mediation is the first 4 things it tells you that, look, have you been to, in fact, what I do is I'll ask you, have you been in a mediation before? Yes or no? If you've been there, it doesn't change my approach. If you haven't been there, it doesn't change my approach. Why do I say that? I say, oh, if you've been there, I say, oh, so you understand the process a bit, but permit me to restate how this would go. This process sits on 4 pillars. 1, I am a facilitator. What do I mean by that? I'm only going to assist you. I don't hold any views. I don't have any predilections towards anybody. I am a neutral. I will only come in to assist you to negotiate and come to an agreement. So this dispute is your dispute. The resolution is your resolution. The offers are going to be your offers. But hopefully through this process, I will assist you to come to acceptable understanding of one another and also to come to acceptable agreements with one another. 2, it is a party-driven process like any other ADR process. I just told you the advantage of ADR. You choose who, when, where, and how your dispute is decided. So it is party-driven, purely. Yes, there are court-ordered mediations, but essentially it is party-driven. And when I find myself in court-ordered mediations, see, sometimes they tell you that mediation is an agreement to go and agree. Again, it comes back to what I said. What if I don't want to agree with you? Can you force me to agree? Can a court force me to agree? Not necessarily. And that is where the skill of the mediator comes in. Because when you have a court-ordered mediation, very often what I say is, look, I know you have come, because sometimes you see the party is already fuming where he's sitting. He's clearly not going to be cooperative. And he said, I'm only here because the judge said I should come here. So what I try to do is I engage the party and I let them realize that you don't lose anything. You don't lose anything. I'm trying to make you see the process as a voluntary process. I'm trying to make him volunteer himself to the process so that once we both know that the process is voluntary, the likelihood is that parties will be committed to the outcome of that process. So I want to bring them in and I want them to see it as a voluntary process. So if he's already on a high pedestal of anger, I try to bring him down. And I try to calm him down so that we can have that conversation. Sometimes they remain obstinate. But through the process, you will see where they're going with it. And they might just latch onto the process again. Then the beauty of it is that it is private and it is confidential. Confidential because everything that you exchange there whether the written statements that you use to tell your story, any document, even the notes that the mediator will take permission from you sometimes to take notes. So every aspect of it is confidential. It cannot be used anywhere. Then it is a private process. You find yourself, isolate yourself into a place where you can have only to yourselves to engage in the discussions. So what do you do to prepare for it? You must appoint a mediator, a standard. Now, ad hoc, mediation, or institutional. Institutional means, and Fumi Yai is going to be speaking to you as an institutional representative of an institutional body, LASIAC. Now, institution means that there is a particular body that is set up to administer the disputes for you. So a body like LASIAC, which is on this webinar, exists to provide services of mediators, arbitrators as well. So they can administer the process for you to make sure it goes seamlessly. Then again, it can be ad hoc. Ad hoc means that both of you decide on the spur of the moment that rather than going to court, let us submit this dispute to a mediation. It is not regulated by an institution. So parties are at liberty to guide how that process will go. Sometimes, therefore, the mediator is also selected by a third party. That third party might be an institution. That selection process might be by the parties themselves. You can reach an agreement. Of course, usually when parties are in dispute, which is the advantage of institutional bodies, it's easier to just submit it to a third party to bring the person that is going to negotiate. Let me not talk to this person until I have to. Then it is not unusual to have a mediation agreement. Yes, you may have it in your contract that you mediate. I imagine Fumi will be talking to you about the dispute resolution clauses. I know Laura said I might do that, but I think that is a better remedy for Fumi because she's talking about the third stage of the process: negotiation, mediation, and arbitration. You hear what you call multi-tier dispute resolution clauses. So you may have to sign an agreement. If, for example, it is a spur of the moment decision, you want to sign an agreement. In the High Court of Lagos, for example, you have what you call the Lagos Multi-Door Courthouse. When you go to LMDC, they're going to give you an agreement by which you say, we want mediation, and you submit to mediation. Prepare brief statements, deal with the mediator's fees, and then all those things that I said about mediation, preparing for negotiation, you have to observe that as well, because the mediator is going to ask you for things like your BATNA. You're going to have to use your BATNA in negotiating. So those are the things that you find useful there. Mediation is in phases, and I'm not going to bore you by going through them, but I'm going to highlight certain things. In the opening, you see there I said something about ground rules. Ground rules. When you open, you introduce, this is who I am. These are the foundations on which this process is lying. And these are, what I mean by ground rules is I make a habit, or let me say I make a practice of telling the parties that, please, you are entitled to be upset. You are hurt. And this process is not going to discount the importance of your feelings. However, do me this favor. Since you want a resolution and the other person also wants a resolution, let us avoid making inflammatory remarks. Let's not insult one another. Remember I said, don't talk at the other person. This is where it plays out. Let's not insult the other person. Let's be very careful and this and that. Please do me another favor. Turn off your phones. It is quite disruptive for us to be speaking and then a call comes in. Oh, by the way, it's not just to turn off your phones. Please keep your phones away. Because when I'm speaking or the other person is speaking and you're on your phone, what you're saying is that what I'm saying doesn't make any sense. So please, so you set up certain ground rules that help you drive the process. The next stage is information gathering. That is where you begin to ask the parties. Now, you will see there that I say caucusing is one of the things. Now, when you have a mediation session, the typical mediation session, mediator is going to say, tell me your stories. Let me understand where you're coming from. So the mediator is the active listener and takes everything in. Ask questions to clear doubt, but takes everything in. The other party also does the same thing. You will probe further. Now, probing or caucusing sometimes requires, or probing rather, sometimes requires caucusing. What do I mean by caucusing? Caucusing means that I will meet with one party away from the other party. Oh, by the way, if I meet with the party, I'll say, look, give me 10 minutes with this party, I will come back to you. If for any reason I'm going to exceed the 10 minutes, it is only proper that I let that party know that, look, sorry, it's taking longer than I anticipated, but I'm going to be with you. Why? Because you must always be seen as neutral. You must always be seen as, so caucusing is something that you will do to get more information. That is where you do a lot of the probing. That is where you find out what the interests are. That's where you find out what the issues between the parties are. That's what the mediator is doing. Now, when the mediator caucuses out, please, I want you to note this very interesting thing. If I meet with party A away from party B, it is very likely that party A is telling me certain confidential things. Those things that will not find their way onto the paper that is already in mediation, that I have to be careful. I must not disclose them to party B. So that confidentiality exists at two levels. At the level of the process itself being confidential, and then secondly, at the level of the information gathering process with the party in dispute. So if I gather certain information, unless that party says that I should disclose it, I should not disclose it. So what I will do is I will ask, do you want me to disclose it to them? If you don't want me to, oh, okay, you can say disclose it only if he says this. Only that. So doing that, you are also instilling confidence in the process and instilling confidence in the party that has retained your services. Excuse me. Now, identification of interests and positions. Please, I will talk about this briefly. I know I had purpose to finish in less than an hour. I'm just slightly over an hour now. But my thing is this. Interest and positions. We often hear interest, or positions. Parties come into negotiation and maintain a position. This is where I stand, and I'm not going to leave that place. Oh, this is what the law says, and I'm not going to leave it. I'm going to stand by the law. But you will find out that that position that he's maintaining is actually possible, that is being governed by, is being inspired by totally different interests. So I'll tell you this story. One day I had to mediate a dispute regarding the sale of a stockbroking license. So it looked very simple on paper. Then we got into the mediation room and we started. Then I realized that beyond the sale of the stockbroking license, there were basic company law issues to deal with, like transfer of shares, who owns the shares, what have been done, whether the capital of the company is being dissipated. All those things started coming out when we were dealing with the opening statement. So I had both contracts as a lawyer now and company law issues that I was dealing with. So, well, let's go on. But I realized that the respondent was being very difficult. So when I had a caucus with the claimant, it was during that caucus session, or rather, somebody was very relevant to that meeting that was not there. So it was during the caucus session with the claimant that I realized why that person wasn't there. So let me rewind. The respondent, the person representing the respondent, was the chairman of the company that was selling the stockbroking license, who happened to also be the husband of the managing director. The managing director was not in the room, and it was the managing director that took most of the decisions, including the decision on sale of the license. Now, it was during the caucus session that I realized that the reason the chairman of the company was being difficult was his ego. Why? Because at that time, he was going through a bitter divorce with his wife. So, from basic contract, I have moved to company law. From company law, I have moved to matrimonial matters. So you have to know what the interests are, what it is that is driving this person to behave in this particular way. And then that is where you begin to work on. If you're doing any reality checking, those are the areas you begin to address as a mediator to help them see how, in spite of that, they can get to where you call destination yes. Bargaining, of course, then starts when you begin to make your offers. We've talked about offers. I'm not going to go into it again. But you see, I put there direct and indirect offers. So it's very possible that when I'm caucusing with party A, let's go back to the zone of possible agreement. We've been discussing since now. We know what the ZOPA is, but party A, who is the seller, party A, who is the buyer, still goes and says, offer him 4 million. In spite of what is clearly before us that tell you that the offer he's making is unrealistic. Now, at that point, and by the way, not just unrealistic, it's perhaps insulting in the circumstances of that reference. So at that point, the mediator might say, you think this is an offer you want to present? The mediator is already looking at it and saying, we've made considerable progress. We're now coming to the money and the bargaining stage. We want to make an open offer. I don't want to be, he won't be judgmental, but he's processing it in his head and he won't say it out. So one thing the mediators normally do is that, would you rather make that offer to the person directly? More often than not, you hear no. The reason is because the man is telling you to go and offer 4 million because he knows he's not the one that has to say it to the person. So when you throw it at him, can you make it to him directly? So when you are having to make an offer, make your offers realistic, very close to, if not in the zone of possible agreement, and be in a position to make it directly to the party, because ultimately, who are the people to implement the agreement? Both of you. So if you cannot speak directly, let us get there. But yes, emotions may have ridden high to avoid it, but then you can still find a way to make those things done. Then lastly, but not the least, there is the concluding phase. You've done the bargaining, you've reached heads of agreement. There are deadlocks. I'm going to talk about deadlocks in a minute. You've reached the agreement and you now conclude. What do you do at conclusion? You compile the heads of agreement, compile the points where they have disagreed. Remember, I said to you earlier on that it's very possible that they don't agree on everything. Confirm that you are clear on those things that are being talked about. Confirm that you are clear, and at the end of the day, make sure that what you have recorded is in tandem with what the parties themselves have recorded. And then you draw up a settlement agreement. Two more things to talk about before I round up this presentation. The first is deadlocks. What is a deadlock? A deadlock arises when neither party is willing to shift. No one is willing to shift. So we go to the negotiation model one. We've done enough compromise. I'm not making any concessions anymore. Because we are fundamentally disagreed on this. Or I'm not going to shift. Let him continue to insult me. Let them continue to play big fish. Let them continue to see me as a small fish in a big ocean. Let them continue to see me whichever way. I am not going to shift. That is what you call a deadlock. What are the things that can cause it? Unrealistic and impractical expectations. You making an insulting offer. We've gone this far, we've made so much traction, and then you now take the wind out of our sail by just making this ridiculous offer. So I think this man is not serious. Let's go back to our trenches. So I stick. Then there is emotional baggage and hurt. So go to the story that I just told you now, that I was actually dealing with a domestic situation. So, deadlock. Sometimes pride. I mediated a dispute where a customer owed a bank money, or the bank is said to have, the bank says that the customer owed money. But in point of fact, the customer, in the middle of the month, paid all the amount that was owed. It was about 200 and something million, and he got a good business deal with which he was able to pay up everything. The only problem was that, as most of you business persons know, when you borrow money, interest does not drop until the end of the month. So he paid the money in full in the middle of the month. But the interest that had accrued did not drop until the end of the month. By the time the interest dropped, the account was already empty. So he began to read again and was being compounded. So when he got the letter of demand, he felt, what nonsense. So he felt very, very good. I'm strong on this. How can the bank be writing a letter to me? Then later, when we got into the mediation, he now realized that, oh, in point of fact, he should have kept some money in the account to deal with the interest element. And that was where the problem of deadlock came. His ego took the better of him, his pride, because he had said all sorts of things. He'd written all manner of letters to the managing director of the bank. He'd taken them to the bankers' ethics committee. He'd labeled them all sorts of things. Now he had to swallow that pride. So sometimes that also is the source of it. And sometimes people just want to stop. That is another problem. So what do you do to break deadlocks? Sometimes you calm their frayed nerves. I told you, you use humor sometimes. You go, who knows, if you made your inquiry, because the mediator also researches the parties, and in the course of talking to them would have found some things. Who knows, maybe he's a football buff. Talk about the things that they like. Talk about the things that are important to them. If there are people that place premium on family, we all work so that we can fend for our families. So look at those areas and begin to explore them. The things you do to break deadlocks are unending, the list of things you do, but you must, as a mediator, deploy your skills. So you, as a party in mediation, must also be able to look at this and avoid the potential pitfalls. Then lastly, the settlement agreement. What do you want from the process? Do you want a contract or do you want a relationship? I've talked about that earlier. I won't go into it again. The essentials of that agreement, however, it is important that you know these things. It can be prepared by the lawyers. So lawyers are not the ones in mediation, but it's good to have lawyers that are mediation advocates that help the process. In my own practice, this is the stage at which you employ the lawyers, because they must have a part to play in it. Then note that you must state the confidentiality, because, for example, the Lagos multi-door concept is there. It is confidential, but sometimes you'll be able to take it to an alternative dispute resolution judge that will endorse it as now makes it a court order. If it is a court-ordered mediation, you're going to go back to the judge and say, we have settled, these are the terms of our resolution, and the court is going to make it the judgment in the case between both of you. Make sure that the people that sign have the authority to sign. Otherwise, you're going to go back to square one. Or put differently, you go back to the proverbial land of Egypt, where you were in captivity before. So the mediator, whichever way, always note he can never be called as a witness. It is always good to make that part of your settlement agreement, even though it is a standard norm, but make sure you put it there. And then also the fact that it reflects the parties' agreement. More importantly, it is in full and final settlement of all the issues that were agreed upon. So ladies and gentlemen, in closing this presentation, what does ADR offer SMEs? I'm happy Abayomi talked about the role of SMEs, what they do, and how pivotal they are in the economy. Holding 70% of the GDP and 85% of the workforce of an economy is not a small feat for SMEs, so they shouldn't be taken for granted. At the same time, SMEs should not take themselves for granted. They need to begin to think inwards and say, look, we're in business, and in any business entity, we will find ourselves in dispute. So how do we resolve it? How do we do it in a cost-effective manner that helps us still continue in the process? I sat as an arbitrator in an arbitration where even though the parties were in dispute, they were still doing business. And this is where ADR comes in. They were still doing business, and they're still doing business till tomorrow, even though one party was adjudged liable to the other. Fumi Yayi again will talk to you about arbitration tomorrow, and I know Abayomi is going to do a lot of that as well. So what does it offer you? A faster and less costly dispute resolution process, a flexible and adaptable dispute resolution process, because you can suit it, is bespoke. You take a measure that suits your needs. Early neutral evaluation for construction industry is good. It is less formal. It is private and confidential. And more importantly, it is consensual and party driven. And where it is consensual and party driven, 9 times out of 10, once it is properly handled, the parties are likely to be committed to the decisions and the agreements that are reached in that mediation. So with this, ladies and gentlemen, I say thank you for listening.
Thank you very much, Mr. Ojo. That was quite informative. I think I see some questions here. I don't know if you'll be able to answer at least 3 of them. And I'll start with the question on, I think, the one that says, please, is a mediator always a lawyer?
A mediator is not always a lawyer, period. In fact, the less loyally you are, sometimes the better, because we carry a lot of legal baggage when we are dealing with this thing. So a mediator does not have to be a lawyer.
Okay, thank you. I hope, okay, it's an anonymous attendee. So then OluwaseyilayO Oduwaye is asking that can settlement agreement be enforced? I thought maybe you just want to quickly touch on settlement of mediated agreement, the Singapore Convention, just briefly.
Singapore Convention, we're going into a minefield. I would suggest we don't
just briefly.
We don't infuse on that. What the Singapore Convention does is basically to create a regime whereby also you can find enforcement of mediation settlement agreements, just like you have in arbitration, where you have the New York Convention on recognition and enforcement of arbitral awards. I didn't see the question about me, but I hope she didn't talk about Singapore Convention, because that's a totally different kettle of fish. But the bottom line is that we are looking now. I think Nigeria has ratified, if I may. I think I'm right to say that about it. We've ratified, haven't we?
Yes, yeah, Nigeria has ratified.
Exactly. So what is ongoing now is we're actually also working on a statute that will incorporate it as a body of our statute. Well, but coming back to the issues of enforcement, I mean, by the way, a convention also creates a platform for you to be able to enforce it not only within Nigeria, but beyond the shores as well, because you're a signatory to the convention. I'm loath to go too deep into it, because I didn't want to really go, because we're talking into international mediation, international arbitration space that I'm being careful not to go into. It's a minefield on its own. But basic enforcement, right? It is confidential between both of you ordinarily. And both of you are going to, so that's the beauty of coming to an agreement that you both are in tune with. However, if you do not have that clause, both of you would have agreed from the get-go where you want to go with this agreement. So if, for example, it is a court-ordered mediation, you're going to go back to the court. Now, if you go and tell the court that, look, what we have agreed upon, we don't want to put it in your records, just know that we have agreed. You put the barest minimum, they have agreed to settle this dispute out of court, blah, 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 and go. The court will allow you. The court will allow you. You can keep it very confidential. It's the beauty of it. But otherwise, you can make it from the terms of settlement of the court.
Okay, thank you very much. There's another question on cost from former. How much does it cost to employ the services of a mediator?
Well, if you're looking to employ the service of a mediator like Dr. Abayomi Okubote, it's very expensive. If you're looking at someone like Laura Alakija, because she cuts a lot of finesse, she's even more expensive. If you're looking at somebody like me, I'm the least expensive of all, but that's just joking about it. But the truth is this. Now, usually it's often best to do it hourly, but if you go to places like the Lagos Multi-Door Courthouse, they have standard rates and standard fees. That's why you have institutional mediation sometimes taking the place of ad hoc, but you have scale of charges that you can use and apply to the process. So some people use hourly rates because how much time I spend, I will be paid for every hour that I am there. So some, if you go ad hoc, have their own personal rates. There is no institutionalized rate anywhere for anybody. I'm not bound by anybody's rates if I want to do that. So I will look at what my own hourly rates are, or what it will make, what it will take for it to be worth my while. If you go to a Lagos multi-door, again, I always recommend that because they do a lot of mediations there. It is much more standardized. They have a rate, they have what you will pay. And Lagos multi-door will deal with the mediator themselves. If you go to LASIAC, Lagos State Chamber of Commerce Court of International Arbitration and all, you will also have their own rates there to apply. So, but you will not have a standard rate that works across board with everybody, even in the field of arbitration. It's no different from how lawyers don't have standard rates for all things they do.
Thank you very much. I can assure you that I'm affordable. The last question, or maybe just take two more. This seems personal, but it looks like something you may want to take. Informer has asked that there is a situation where the court ordered out-of-court settlement, and after several years, nothing has been done. Parties are now before the AFCC, yet one of the parties has insisted on not coming to court. So he's asking for your suggestion.
Well, that is difficult because it sounds very much a matter that has lawyers involved. So you'll be taking independent legal advice. I'm always wary sitting in the gallery and commenting on what somebody else is doing. But notwithstanding, I will offer a perspective on it. And my perspective is very simple. To start with, a court cannot order you to go and settle, because the role of the court is to determine the dispute. If you could settle, you would not come to the court in the first place. So it is not the remit of the court to order you to go and settle, unless you tell the court that, look, we want some time to go and try to resolve the matter. Now, even that time granted you by the court is meaningless if it is only one party that is driving it, and the other is being the proverbial unreasonable person. And unfortunately, where you start having criminal undertones, maybe one party is trying to dominate the other. That is the model of negotiation that involves domination by using the police or using any form of harassment. So some of these things are not right. This is where you have to come back and think. But more importantly, it is about the counsel, the individual legal representations that they have and how they are able to use them. What exactly do they want from the process? And if you see that the matter is not going anywhere, then go back to court, because the court is there waiting for you.
Right. I agree. So the last question says, can ADR and mediation be done online? I think this is about ODR. And what tech tools and software will be needed?
I will leave that to Laura to comment on, because she's an ODR practitioner. She has certified training, but there are various platforms that have been set up for this, especially during the COVID era. You had a lot of innovation. Take, for example, we're using the Zoom platform now. Who knew about Zoom in December 2019? Those who knew about Zoom in December 2019 were not as many as knew about it now. If you take the share price of Zoom in 2019 compared to what the share price went to in 2020, and Zoom has already improved on those platforms. Now, what happens is that there are some apps and some organizations that have set up a system that partners with Zoom. For example, Opus, right? So you can have online dispute resolution that can be done. Even in under the auspices of Chartered of Arbitrators, we train using the big blue button. There is a platform where they can have the mediations done online. It is now becoming very well accepted, and it is ongoing. So the simple answer to the question is yes, it can be. Research it. Again, I always say the wonders of Google. But beyond that, you have the likes of Laura. I mean, I don't know if she may want to comment on this, who's done training on that. I've done virtual arbitration before. I've done virtual hearings in arbitration before using the Opus platform, and it's just as efficient, and maybe not 100%, but at least I can say 80% of it worked during the arbitration.
Thank you very much, Mr. Ojo, for that. And thank you for the session. Thank you for your time. On this note, we've come to an end, to the end of today's session. Thank you, everyone. I see that about 79 attendees waited till the end. So just send your names, the full names, the way you want them to appear on your certificates. Send it to us, info@princeblaw.com, so that they can work on your certificate. If you have any other question that has not been answered, just also send to info@princeblaw.com. So thank you for your time today. Thank you again, Laura and Mr. Ojo, for your time. We'll be meeting tomorrow at same time, 10 a.m. And I promise you that before 12:30, we should be done. So thank you, everyone. Enjoy the rest of your day, and see you all tomorrow.
Thank you for having me. Thank you.
Thank you. Bye.
Bye. Bye, everyone.
Yeah. Thank you.
You brought it?
No, one of the ones Darren gave me.
Darren gave me.
Yes, did you see him giving me clothes? Sherry, you saw that he gave me watch. Yes, and whenever I lost that, okay. Ooh, tick, 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 tick. Oh, yeah, different things. So there's another earring and a bangle, then this one, small earrings and a long. Ooh, perfect.
Awesome.
See?
Awesome.